stopping in between and having a different range may not be appropriate. Yes, please.
Wait, please. So the issue here was short one. Suit filed for declaration as well as for injunction. Both the trial court as well as the first appellate court.
What's wrong with the impugned judgment, Mr.
The declaration is actually
where's your partition? Which page is your partition deed?
Sorry, brother?
Which page is your partition deed?
No, the suit was filed by the plaintiff alleging adverse possession as well as possession in terms of a 1940 sale deed. Both the trial court and the first appellate court hold in my favor. I'm the defendant, saying that they have not been able to establish their title. Despite doing so,
no, I thought that the
court
did hold this title, but they did not grant
it's the reverse.
The appellate court reversed the injunction.
No, I'm so sorry.
Trial court is in my favor.
The trial court said that the injunction was granted by the trial court, has been reversed by the first.
I'm most obliged. On the issue of title, both courts are in my favor. Please have straightway endorsed the trial court.
So the sale deed of 1940 is not proved or
not at all. In fact, doesn't pertain to this. Page 27 is the trial court judgment.
Page?
Please have 27 at 32 straight away. I'll show the finding, but in the issues which the trial court lays out, the title is held against the plaintiff in favor of the defendant. Still, the injunction is granted.
Because he's in possession.
I'm most obliged, and that's the seminal question.
Permanent injunction, not the
Well, where is the finding with regard to the ownership?
Please, but straight away, would your lordships have page 33? It begins at 32. There is a table there.
Yes.
Tribal question, whether the suit land, the title of the plaintiff is clear based on the ground of adverse possession. Conclusion has not proved. The discussion is in para 6. Please leave the factual portions. Please turn to 33. About last 7 lines of para 6. Therefore,
there is no basis
of this argument that the suit land was belonging to Premlal Halwai. It is also established that no one can give a better right for himself likely in this case. On exhibit P1, if a wrong line is marked, then in someone else's land, the right of others will not be destroyed from the said report. Please then have para 7. But specifically then para 8, from 1954 onwards, the mutation entry is in my favor. Conclusion at paragraph 16, page 38. Page 38, paragraph 16. Based on the above position and after duly respecting the citations presented above, in this case, the title of the plaintiff could not be proved on the basis of adverse possession. Therefore, the answer to the tribal question is given as not proved as mentioned. Now, the only thing then after that, the learned trial.
So tell us one thing. Once they accept, who's in possession?
It was my case, I am in possession. It was their case, they are in possession.
But as per the findings recorded by both the trial court as well as the high court,
I am obliged.
they are in possession.
Your lordships are right. The trial court, as a matter of fact, found that they are in possession. The first appellate court, as a matter of fact, found that I am in possession. The Honorable High Court, without, in my humble submission, without there being a substantial question of law, which is a jurisdictional issue.
Oh, that will not also.
He appreciates that evidence to say they
even
are.
If there is no specific issue framed, but if the issue is arising,
the issue is there.
1 minute, please. If the issue is arising and has been gone into by the trial court as well as the high court and as well as the first appellate court and the high court, we
the lordships have held
that where let's not be technical. The lawyers are not well trained also. So
your lordships have held that where the title has not been proven, the consequential relief of injunction can't.
Possession is something different.
Would your lordships just have a look at this court's decision?
Look, trespassers' right is something different, and a settled possession, even if wrongly claimed. What are the Jamabandis after 57 indications?
All in my favor. Everything in my favor. Till 1990, he moves an application before the revenue Tehsildar saying, please change my entry into his favor. that is done in 1990, I challenge it in appeal, which is reversed in 1994 in my favor. Every single mutation entry is in my favor, in my name solely. And that is part of the reason for showing that possession is actually mine.
Did any of your witness say, D3 say that he is in possession?
Because what happens is
DW3 said that.
entire confusion arises out of paragraph 4 of DW3. That's the one who says they are not, but simultaneously says that the crop
Is the version of
please but straight away, DW3, it's in additional documents at page 67. 67 of the additional document.
DW3 says that PW3 is cultivated or
I'm most of that. And after having said, there are three versions of DW3. So, and this is where the entire confusion arises. Please have first page 67. Paragraph 1 first, which is the chief examination.
page 67.
67 of the additional documents.
Yes.
About 5 lines from the top in paragraph 1. On the suit land, Santram, that's the defendant, does the cultivation. In this year in the suit land, till is cultivated. Since last 40 years, Santram and Jawahar, who are the defendants, are doing cultivation in the suit land. I have not seen any time doing the cultivation work to Hari Maharaj. Now please see the cross, paragraph 4 at page 69.
Yes.
It is incorrect that in the suit land, never the cultivation of till has been done. It is correct that in the suit land, Manharan cultivated pumpkin. I cannot say that only Manharan cultivated the pumpkin in the suit land. It is correct that since 8 to 10 years in the suit land, Manharan cultivates pumpkin and tomatoes, etc. It is correct that Manharan cultivates from the side of Hari.
He's accepted this.
So this as Manharan, who's 2-3 of the idea where it is.
But this is a clear admission that he's in possession of.
I bow down. On that basis, there's the
that
finding.
is your witness. You did not re-examine him.
I bow down. I'm saying on that basis, the finding of he is in possession comes to be passed. Now, please consider the legal question that where a party has failed on the title, even assuming that he is in possession, can he maintain an injunction against the rightful owner of the land, which your lordships have considered and decided in my favor?
Will be injunction only to the limited extent. You may unsettle him, take his position in accordance with law.
Your lordships have considered that issue of accordance with law. Could I trouble your lordship?
We can modify that. He is to be granted injunction to the extent that he will not be dispossessed except in accordance.
In fact, your lordships considered this question of should I be relegated to file a suit for dispossession of the plaintiff. That your lordships considered in 2022 12 SCC 128. Would your lordship just have this? Justice Shah's decision. I'll pass on a copy as well. Uh, 2022. Yes.
What is the page number?
The judgment Pullad's page begins at page 128.
128.
Your lordships will find a marked similarity, even in fact.
I have the judgment. I have the judgment. I have.
Please first have paragraph 5. At this stage, it is required to be noted that so far as the judgment and decree passed by the trial court refusing to grant the decree of cancellation of registered sale deed and refusing to grant declaration of title of the property in her favor attained finality, and it was defendant number 1 who unsuccessfully preferred the appeal before the first appellate court challenging the decree of the permanent injunction in favor of the original plaintiff. Let's please then have arguments at paragraph 9, which is what I am urging for your lordship's consideration. Learned senior advocate appearing on behalf of the original defendant 1 has vehemently submitted that once the relief relating to declaration as to title of the plaintiff to suit land is declined, the trial court erred in granting the relief of permanent injunction to protect the alleged possession of the plaintiff. Your lordships will then come to the consideration from paragraph 11 onwards. And please have para 12.1. On appreciation of the entire evidence on record, the trial court refused to pass the decree of cancellation of registered sale deed and refused to grant a declaration as prayed. Therefore, so far as the aspect of title of the land in question is concerned, the plaintiff lost. On appreciation of evidence, the trial court held that the husband of the plaintiffs executed a registered sale deed in favor of defendant 1 for valuable consideration. On the judgment and order passed by the trial court refusing to grant the decree of cancellation of the registered sale deed, and the declaration has attained finality because no appeal was filed by the plaintiff. 12.2. However, the trial court granted permanent injunction in favor of the plaintiff, restraining defendant 1 from disturbing the possession of plaintiff with respect to 5 acres 15 guntas of land. It was defendant 1 who preferred the appeal before the first appellate court and thereafter before the High Court, challenging the decree for permanent injunction. The High Court, by the impugned judgment on order, observed that as relief for permanent injunction by the plaintiff can be said to be a substantive relief, therefore when the plaintiff is found to be in possession of 5 acres 15 guntas of land, the plaintiff is entitled to the relief of permanent injunction for protecting her possession. Therefore, the short question which is posed for the consideration of this court is whether in a case where the plaintiff has lost so far as the title is concerned and the defendant against whom the permanent injunction is sought is the true owner of the land, whether the plaintiff is entitled to a relief of permanent injunction against the true owner, more particularly when the plaintiff has lost so far as the title is concerned, and can thereafter the plaintiff be permitted to contend that despite the fact that the plaintiff has lost so far as the title is concerned, her possession be protected by way of injunction, and that the true owner has to file a substantive suit claiming the possession. So far as the submission on behalf of defendant 1, that even this, please, your lordships can leave the first 5-6 lines and please come to placitum E. It is true that there are concurrent findings by the trial court as well as the first appellate court that the plaintiff is in possession of the disputed land in question. However, it is required to be noted that in the revenue records, right from 1976 onwards and after the registered sale deed in favor of defendant 1, the name of defendant 1 was mutated in the revenue record, and in the column of farmer and cultivator, the name of defendant 1 is mentioned. Even the crops being cultivated by the cultivator are mentioned in the revenue record. Thus, right from 1976 onwards till 1997 in the revenue record, the name of defendant 1 is mutated as an owner and cultivator. Nothing is on record to the effect that any point of time after the registered sale deed was executed in favor of defendant 1, plaintiff paid any revenue in respect of land in question. After the execution of the registered sale deed in favor of the defendant 1, which has been believed by all the courts below, the name of defendant 1 was mutated in the revenue record as an owner and cultivator, and the plaintiff who claims to be in possession and cultivating the same is deemed to have knowledge of the said entry. Your lordships will then come to paragraph 17. And please come to placitum F. It is true that under normal circumstances, the relief of permanent injunction sought is a substantive relief, and the period of limitation will commence from the date on which possession is sought to be disturbed, so long as the interference in possession is continuous. However, in the case of a consequential relief, when the substantive relief of declaration is held to be barred by limitation, the said principle will not be applicable. Even otherwise on merits also, the court, that's an issue of factual portion. I'll place 18 minutes. Even otherwise on merits also, the courts below have erred in passing.
Now, Mr. The 17 may be a debatable legal proposition because otherwise you'll have to then file 2 separate suits.
Plus, in fact, please have 25 last 5 lines, and then their lordships considered Anatula Sudhakar and said that once in this particular proceeding, the title has been considered, then there's no question of relegating me. Please have page 141 of the report. Actually, page 140, I'll begin with para 25. An injunction is a consequential relief, and in a suit for declaration.
You're not a plaintiff. You're not filed any cross objection.
I'm most obliged. And
you're not filed a cross.
I hadn't, for the simple reason the suit has gone into the.
There are 2 facts. There are 2 things. One, there is no cross suit by you. Question of possession is always a question of fact.
I'm obliged. Physical
Physical possession is always question of fact. There's a term called settled possession, which probably has been defined.
And that's what has been used by the Honorable High Court.
That's undefined. Well, to be very frank, undefined by
Please.
most judgment. Probably is saying that it continuous possession over a period of time, which shows that it's not being challenged or it's not disturbed. You can take it as a settled possession. It's not a fleeting possession. It's not something which you do merely as a licensee.
Please.
Something more than this possessory right which you claim and which you have don't actually to exist. That's the best way to define it. Beyond that, I don't.
Could your lordships, your lordships in this judgment dealt with the issue that your lordship put to me? Please have para 26 onwards.
Yes.
This is the question that your lordship put to me. So far as the submission on behalf of the plaintiff, that even if the plaintiff failed to get the declaratory relief and relief for cancellation of the sale deed and her suit for relief came to be dismissed, the plaintiff is found to be in possession. Therefore, the only remedy available to the defendant would be to file a substantive suit to get back the possession is noticed only to be rejected outright. It is the contention on behalf of the plaintiff that once the plaintiff is found to be in possession, her possession cannot be disturbed except by due process of law, and defendant one, though may be the true owner, has to file a substantive suit for recovery of possession. While considering the aforesaid submission, the decision of this court in Maria Margarita Sequeira Fernandez is required to be referred to. What is meant by due process of law has been explained by this court in para 79, which reads as under. Due process of law means that nobody ought to be condemned unheard. The due process of law means a person is in settled possession, will not be dispossessed except by due process of law. Due process means an opportunity to the defendant to file pleadings, including written statement and documents before the court of law. It does not mean the whole trial. Due process is satisfied the moment the rights of the parties are adjudicated upon by a competent court. In the said decision in Maria, the court has approved the following findings of the Delhi High Court in Thomas Cook versus Imperial Hotel. The expressions due process of law, due course of law, and recourse to law have been interchangeably used in decisions referred to above, which say that the settled possession of even a person in unlawful possession cannot be disturbed forcibly by the true owner taking law in his own hands. All these expressions, however, mean the same thing. Ejectment from settled possession can only be had by recourse to a court of law. Clearly, due process of law, due course of law simply mean that the person in settled possession cannot be ejected without a court of law having adjudicated upon his rights qua the true owner. Now, this due process or due course condition is satisfied the moment the rights of the parties are adjudicated upon a court of competent jurisdiction. It does not matter who brought the action to court. It could be the owner in an action for enforcement of his right to eject the person in unlawful possession. It could be the person who is sought to be ejected in an action preventing the owner from ejecting him. Whether the action is for enforcement of a right, which is recovery of possession, or protection of a right, injunction against dispossession, is not of much consequence. What is important is that in either event, it is an action before the court and the court adjudicates upon it. If that is done, then the bare minimum requirement of due process or due course of law would stand satisfied, as recourse to law would have been taken. In this context, when a party approaches a court seeking a protective remedy such as an injunction, and it fails in setting up a good case, can it then say that the other party must now institute an action in a court of law for enforcing his rights, that is for taking back something from the first party who holds it unlawful?
Before we pass a degree in your favor.
I'm so sorry.
We pass a degree in your favor.
Let's-
Will you execute it?
My submission is this. The question of the plaintiff went and said, please grant me an injunction protecting my possession against the true owner of the property.
Grant injunction, you can't. Will you be able to
I am
take-
seeking a dismissal of that suit. I'm not seeking any decree in my favor. I am seeking a dismissal of that suit. But the plaintiff, I'm most obliged. The plaintiff went to court saying,
Yes,
please.
what do you say?
My lords, a cross suit has not been filed. How can I be dispossessed?
No, 1 minute. We'll simply dismiss your suit.
My lords, how can I be dispossessed? He has not.
No, we'll simply dispossess your suit. That's the end of it.
My lords, then I'm placing reliance on how the title has been accrued with respect to from adverse possession. My lords, may kindly see the
Please,
judgment.
please.
I've given the citation.
Not
Please see,
filed
my
an
lords.
appeal.
You're-
I have crystallized my title with adverse possession.
That is already rejected by the
Yeah.
trial court. You've not filed an appeal against.
My lords, we haven't, but the
Where is the
question of
the
fact, my
recommendation?
lords, on a fact finding file. fact has been in my favor
And
that
in
I had the
fact,
possession.
same title through a sale deed, which is in contradiction.
1943.
That's it. And you
What
can't
had
claim for
transpired-
two things at the same time. There's mutual contradiction in
My
this.
lords, what had transpired was that the Tehsildar had held in my favor. My lords may see the first document. The first document held that I am in possession. Please see, my lords. Kindly see my counter affidavit.
I'm going to that question.
Still taken. It's what you are saying.
My
Right
lords,
on.
kindly see my counter affidavit. My lords,
Counter
my lords.
From that issue
Say,
at all, madam.
No,
What-
we can't go into the adverse possession. Once you're claiming your right, your right in entitlement through a title document, you can't claim adverse possession. For adverse possession, you have to have that animus discharge.
I quite see, my lords, what's
When you're
fallen.
claiming
But-
it, and you have to be, your position has to be hostile to the actual owner. That will not happen because you claimed your
My
right
lords,
to
the oral
L1.
statements have been all in all that I have.
Please, there's
My lords,
mutual
the oral
contradiction in
statements have
that.
been in my
That
favor.
cannot take
Also, my lord, I quite see what's fallen, my lords. The corollary of the suit being dismissed would eventually means that he would have now his right would be there.
Whatever it is, he's not getting a degree. We're not passing a degree in his.
But it opens a right for him. We have been, my livelihood has been there, my lords, in 1940 onwards. We are cultivating the entire.
Okay, on that again, there's a difference. In 1957,
My lords.
there's a revenue Jamabandi is in his favor. So that again is oscillating. It's not.
My lord, it's
something
the first proceedings by Tehsildar is in my
filed
favor.
only 1970.
Because I got to know that erroneously his name has been
70,
indicated.
you became the owner, probably you filed this in
Indicated.
17.
My lords, my father had it as a name. That's how the title was.
But 15.7, this title is.
My lords, my father was paralyzed. It's an admitted fact. Even they are admitting and therefore these individuals were cultivating the land.
Anyway,
Now we have been
this is
living
so-
on these
this
lands
is
for the
just-
longest time.
Right up. Leave granted. We've heard learned counsel for the parties at some length. And of the opinion that the impugned judgment allowing the second appeal filed by the respondent, that is legal representatives of Hari Shah, the original plaintiff, should not have been allowed. Next paragraph. The trial court, as well as the first appellate court, had dismissed the prayer for declaration by Hari Prasad, since dead and represented by his legal representatives of title based upon a sale deed exhibit,
P1.
One man.
sale deed exhibit P1, executed by Premlal Halwai in favor of Harilal's father, late Harilal's father, in the year 1940. Stop. The trial court and the appellate court had examined the question, the question of title with reference to the location of the land in terms of Khasra numbers, etc., to reach the said conclusion. So stop. Further, Harilal, the late Harilal, had not challenged the judgment of the trial court in the first appellate court. So stop. Appeal was preferred against the judgment of the trial court by the defendants to the suit. What's their name?
Santram and Jawahar.
Santram.
Santram
Santram
and Jawahar.
and late Jawahar, who's now represented by his legal representatives. To the extent The trial court had granted degree of permanent injunction. Full stop. Late Hari Ram, now represented by his legal representative, had not filed the first appeal. Hari Prasad had not filed the first appeal against dismissal of his suit stroke prayer for grant of declaration of title. So, in our opinion, therefore, the High Court in the second appeal erred in granting and declaring the suit stroke prayer for title by late Hari Prasad, now represented by his legal representatives.
I'm sorry, the Honorable High Court has not disturbed even the title,
Okay,
only with reference to
okay. Next page, just write that up. The High Court had however granted relief of permanent, has however reversed the decision of the first appellate court and passed a degree of permanent injunction. Stop. On the said aspect, there is a recent decision of this court in 2022 12 SCC 128, in which it has been inter alia held as under paragraph 26 and then 28, 27 to 28. To start. In view of the aforesaid position, we allow the present appeal and set aside the degree of permanent injunction passed by the trial court, passed by the High Court in the second appeal. To stop. See how clarified, no degree of possession, etc., has been passed by this court.
Legal remedies be left open, my lords.
We are not saying it.
My lords, my lords may kindly indicate that we've been living for the.
All, that's all.
My lords, this order may be construed
The appeal
that is
judgment
possessed,
is
my
decided.
lords.
And the appeal is allowed in the aforesaid sum.
Well, it's just-
Filed by
Legal remedies.
Santram and
no, suit filed by Hari Prasad.
suit filed by late Hari Prasad, now presented by his legal representatives, will be treated as dismissed.
I most open.
My lords, my remedies may be left open, my lords.
That's all.
Possession, my lords. My lords, I have succeeded on the issue of possession, my lords.
That's all, please.
My lords, may kindly indicate we've been living our entire livelihood.
That's all, please. That's all.
Very good. My lords.
Yes. What is this petition? You are, what's your name, Mr. Banerjee? You are.
Your Lord,
What is this petition?
the petition.
But maybe you work for a month and now you're fighting so long.
Your Lordship, no one is taking cognizance of.
So, obviously, if you take such praise, how is going to take cognizance and what can be done?
The decree also now in this favor.
I know. What is 420, etc.? Please don't spend time in the court like this. Hardly anything. What's your grievance? I can't understand your grievance also. You appointed, they terminated your employment, you said you are not being paid the money, you got your degree, whatever it is.
Your Lordship, I filed an FIR. That is,
There's nothing in that. This is not 420, etc. Don't waste your time like this in the courts. And this is not the matter which we'll go into. Right now.
What have you done with your decree? Did you file any execution proceedings? You've secured a decree now for payment of that past salary. What have you done with that?
they are.
There are proceedings to be initiated once you have a
It
decree
is,
and that
it is
is
not possible. It is not possible because their whereabouts are not known. The police is not helping out.
of 2018 in 2021. What is to be done?
You take recourse to whatever remedy now in the terms of Lalita Kumari, etc. Those judgments says if there is something, you file 156(3) proceedings, whatever it is. Can't go into all this in the 32 petition. Right? We are not inclined to entertain the present petition under Article 32 of the Constitution of India. Of it. Legal remedies, if any, available to the petitioner. We, however, do not comment upon any other legal remedy, if any, available to the petitioner or on the merits of the matter. Know the case.
Only one small indulgence. I'm appealing for NMDC in those 3 or 4 matters which are connected in this. So afternoon, I'm in some parted matter. So let the matter start. You'll not subject to
Will it be over today? Because this bench is only for today.
I don't think. We will also have heard this matter earlier on a number of occasions.
Last time, forest rights,
Combination.
Forest development tax or fees.
Yes. But now, will it not, the judgment of the services, with the now the judgment of the
9 judges.
9 judges, will it not have?
Does not cover the matter at all.
According to us,
When it was argued last time, it was said, please wait the judgment.
That is how it was, John, that last time.
That is why it was not. Now you change your stand.
No, that was the submission made by one party with which we did not agree.
according to me, the judgment covers one argument against my learned friend.
That's
But whether he is relying upon that entry or another entry, we'll have to hear him.
No, that I'll open
If
my
he
case and
relies
explain
upon
that.
one
We'll
entry,
take it up on another day. This page may not assemble, otherwise we'll have to treat it as parted and reassemble every now and then. Maybe we just don't take it up. It will be better. Because I don't know whether this combination, because
it will take a certain amount of time.
My lord, may I suggest in that event, let it retain the position.
it will retain its.
Of course.
And
Please check the office report, service is incomplete in 2 of the matters.
Can we have
Service is incomplete in 2 of the matters.
no, it was heard for a number of days, then other parties also keep on joining in so many matters.
Process might turn out to be futile if that party comes forward and says, I've never been heard.
Please check up if there are some unserved respondents.
Very well, we'll check.
You have to serve them because otherwise the case is not fit for, we can't take it up for hearing. The logistics do not permit us to take it up for hearing.
refund, nothing.
Check it out.
We're not got the benefit of the judgment at all.
Right, not to be, present appeal is not taken up for hearing. To be retained on board. In the meanwhile, it will be open to the petitioner, to the applicants to examine whether to take steps for service of unserved respondents. Within 7 days, notice will be given thusly as well.
Would my lords consider a fixed date, my lords?
No, it will remain on board. It will remain on board. It will be number 1. Whenever the regulates list is taken up, it will be number 1.
Very well.
Whenever it
All right.
is dangerous, Lakshmi, let us know a little bit in advance.
Oh, no. Let me put it, the day regular list is taken up, it will be number 1.
Very well.
Very well. Very well.
Very well, ma'am.
I was telling my learned friend that after your lordship, 9 judges, we find him more frequently on our side. That's
No, 9 judges will try to. Anyhow, when we
We're
open the
surprised to
case,
find
the so many
this
things will become clear.
Okay.
obliged.
Much obliged.
Numbering of the on the last two.
Maybe, Jalal. I appear for the respondents. This is squarely covered by a 3-judge bench decision of your lordships. In 1999, 1 SCC 123.
He had on the last date asked you, will obtain instructions whether appeal preferred by the respondents.
Well, appeal,
Decided and the.
so wrongly noted, one of the appeal was preferred by the other side, by the, in fact, it is covered if your lordship will see.
Lordship's request for passover, Mr. Chitle is held up in another court.
Please call him.
Well, in the meanwhile, your lordship, I will look at 1999, 1 SCC 123. Squarely covered. But this was an appeal, here also, this was an appeal preferred under the BMC Act, which is a code by itself. Your Lordship, have a look at 1999, 1 SCC 123.
1999.
1 SCC 123. Chief Justice Anand's judgment, Manoj. The bench was of Justice Kripal and Justice Khare, all three of them were Chief Justices. Your Lordship will see. Para 2, Para 3. It's a very short judgment, Manoj. Here the respondent, Manoj, had preferred an appeal. My Lord, the Chief Justice got it, Manoj?
Yes.
No?
1999 1.
99, 1 SCC.
What was the difficulty?
123.
Not coming up.
नहीं आया नहीं आया
है नहीं क्या?
Just wait for a minute. Yes.
Sometimes I prefer, but the old system was better, the books were better. है?
Nothing different. They read out what is.
Yes, I'll read out. But here what had happened was that an appeal was preferred by us to the small causes court against the order of the BMC Manoj on assessment of our property. Appeal is under section 217 of the BMC Act. Now, Manoj, against that decision, I won in that appeal. So against that appeal, Manoj, a second appeal had to be preferred in the High Court. So, Manoj, this court in this State Bank of India's case 1999 1 SCC has held that it will be numbered as a second appeal. Naturally, because an appeal court's judgment, if you appeal to another court, will be an appeal. The BMC said, no, it is the first appeal. So, your Lordship have held, I'll read it slowly, Manoj. Your Lordship will see Para 3. And the issue only here is that it should be considered as not as first appeal, but second appeal. That's the point. The respondent herein had preferred an appeal before the additional Chief Judge of the Small Causes Code under section 217 of the Bombay Municipal Corporation Act 1888. The learned additional Chief Judge on the Small Causes Code decided the appeal by the order dated so and so, agreed by the order passed by the learned additional Chief Judge, Small Causes Code. The respondent filed a second appeal in the High Court under section 218D of the Act. The learned single judge of the Bombay High Court on 31st January 97 allowed the appeal partly. Allowed the appeal partly. The learned single through a letter patent, an objection was raised by the division by the Lordship. Can skip that. The Lordship will come to Para 6. In fact, Para 5 minutes. The Bombay Act 1888 is a complete code and contains provision for filing an appeal, etc.
Yes. Let's see that first the provisions of law.
Yes, ma'am. Para 5 of the judgment itself shows that. Bombay Municipal Corporation Act 1888 is a complete code and contains provisions for filing appeal, etc. against the order made under the Act. Section 2171 of the Act provides. It says, subject to the provisions hereafter contained, appeals against any rateable value or tax file or charge under this Act shall be heard and determined by the Chief Judge of the Small Causes Court. Now, para 6 Manoj. A bare reading of Section 217, subclause 1 of the Bombay Municipal Corporation Act shows that the jurisdiction exercised by the Chief Judge of the Small Cause Court is an appellate jurisdiction. Section 218 provides for a period when the cause of complaint can be said to have accrued for filing of an appeal under Section 217 of the Act. It is therefore futile to contend that the proceedings under Section 2171 are original proceedings in the first forum. The proceedings are appellate proceedings in the second forum and not original proceedings in the first forum. Against the appellate order of the learned Chief Judge of the Small Causes Court, an appeal is provided to the High Court under Section 218D. Section 218D reads as follows. An appeal shall lie to the High Court from any decision of the Chief Judge of the Small Causes Court in an appeal under Section 217 by which rateable value in excess of 2,000 rupees is fixed. The Lordship can skip that. The provisions of subclause
Just
B.
read B.
Yes, now the Lordship will come to para 9.
Let us read B first.
Para?
B.
Yes, Manoj. From any other decision of the said Chief Judge in an appeal under the said section upon a question of law or usage having the force of law or the construction of a document. C.
Just read. Now, from a decision of a Chief Judge of a Small Causes Court and in an appeal by which rateable value in excess of 2,000 rupees is fixed.
Correct.
Now, this is an appeal which will be filed on any aspects, on any question of law, without any embargo, going to the question whether it's a substantial question of law or
a question of law, correct.
When the rateable value is more than
2,000 rupees. Correct.
Number 2, B, if you look at, from any other decision of the civil judge, that means a decision which is not dealing with the rateable value.
Yes.
In that appeal, under the said section, upon question of
Question
law
or usage, correct.
the question of law and substantial question of law, I'll treat it as same because question of law also, substantial question of law, we have defined it as means
Correct.
anything which is of substance or to the subject matter.
Correct.
It need not be,
No, you're
not be of substantial public importance.
No, that's a different one. That 136 is very different from section 1. You
Now-
now read clause 2.
Now, or uses having force of law or construction of a document.
Correct.
Now, provisions of
The provision of the CPC 1908 with respect to appeals from the original decree shall, so far as they can be made applicable, apply appeals under section 1 on any orders passed thereunder by the High Court made on an application. Now, your Lordship will come to para 9. Lordship will come to para 9. Well, para 9, my lords, may see.
recorded by
Para 9, Lordship may just see para 9. Thus, according to section 218D, an appeal shall also lie to the High Court from any decision of the Chief Judge of the Small Cause Court in an appeal under section 217 upon a question of law or usage having the force of law or the construction of a document. Now, the said respondent had taken recourse to section 218D1 in filing an appeal against the appellate order of the learned additional Chief Judge of the Small Causes Court is not in dispute. Same here, my lords. The appellant had not questioned the maintainability of the appeal filed by the respondent under section 218D of the Act before the learned single judge of the High Court before us. Thus, it is obvious that the appeal filed by the respondent under section 218D of the Act was a second appeal against the appellate order made
What
by
was the issue in this case?
Sorry?
What was the issue, legal issue raised in this?
Same issue, my lord. Rateable value, same issue. I filed an appeal
But
before
the
the small
judgment
court.
doesn't deal with clause A.
Clause A, my lord, from the decision. Lord, any
It refers only to clause B.
no, my lords. It's Para 9, my lord, refers to the fact that once an appeal is filed,
So you read it,
Doesn't say
yes,
that
yes.
they are people.
Thus, according to section 218D, an appeal shall lie to the High Court from any decision of so and so
correct?
in an appeal under section upon question of law and or usage having force of law,
Or the
construction
construction
of
of
document.
a document.
This is only referring to, they read the word and as being a second condition.
So section 218D appeal, once it goes to the High Court, becomes the second appeal.
Lordship,
So
Lords, I appear, my lord.
Yes,
Placitum
please.
FNG.
Lordships, council has gone through VCs.
Yes, please. Yes, Mr. Chitle.
I'm sorry, my lords. I'm extremely sorry, my lords. I was on my legs and I'm extremely sorry.
Yes, is it not covered by this decision of 1999?
Lord, if your lordships permit me, my lords, I'd like to come physically and do the matter, my lords. I am
No,
sitting
no,
stuck.
please, Chitle, we have understood the argument now. Please answer us.
Lord, it's not covered by that because
Look,
yes.
we have gone through the clause 218D, correct?
Yes, yes,
Now, assuming there are also two interpretations possible to it,
yes.
why should we disturb something which has been in force or has been understood since 1999? Today we are 2023.
Lord, I'll answer that question. That particular matter which came up before our lordships, the question was whether a letters patent appeal will lie against an order passed in second appeal.
Correct. That was correct. That's a legal issue because
Yes.
second appeal will not lie against the or letters patent will not lie against a letters patent appeal.
Correct.
And that's right. And
Correct.
have to also curtail the number of opportunities of appeal.
That's right. So therefore, my lord,
Number two, the appellate tribunal normally only goes into the question of rateable value. Now, while going into the question of rateable value, one way to look at it is that it should be more than 2,000 rupees. Rateable value issue should be more than 2,000 rupees because small little claims, the High Court will not entertain against the order of the small causes court.
That's right. That's
The
right.
words in clause B from any other decision. Now, any other decision can be interpreted in two ways. One is clause A applies to decision where rateable value is less than 2,000 rupees.
Right, my lord.
Where the rateable value is more than 2,000 rupees, then it is any other decision. Maybe we are stretching that word. Maybe we are stretching that word. But
No, there's no issue as far as that part is concerned, my lord. There is no issue.
Let it be, Mr. Chitle. Let it be.
Lord, may I just point out 218D?
Do you think that rateable value thing should go to two benches from a single bench to a division bench in the High Court?
No. All that I'm saying is this, my lords. Kindly see 218D, 2.
We have seen that.
2, subsection 2.
Yes,
Because that gives a hint as to the nature of proceedings.
Let's not go into all that. Let's not be right on.
Lord, in this particular case, my lord, our application for bringing on record the legal heirs, my lord, that has not been finally disposed of.
So that's fine. We are not dealing with that issue.
Very well. Very
We are already there, Manoj. We are substituted and I am appearing for legal aids.
Yeah, so it
Yes,
has been allowed.
Yes.
Right on. Legal representatives of the deceased respondents are taken on record as there is no objection. Abatement, if any, is also set aside. Right. Having regard to the decision of this court in 1999, 1 SSC 123, which has held field for more than 2 decades, we are not inclined to take a different view, and accordingly, the appeal is dismissed.
Lordship, please.
I'm deeply obliged.
Yes, it is.
My lords,
Yeah, thank you.
my lords, this is the matter I had mentioned in the morning.
It was to be settled. What happened?
My lord, settlement didn't go through.
Settlement has not failed.
We tried along the same lines which the Chief Justice had on a previous occasion suggested. So the bank was also willing. The bank also said that they would, they said that they would give the money with some interest. We said we will top it up because I am in possession, Your Lordship recalls, under the sale certificate since 2010.
The council is not ready, it's not available today.
Yes, my lord. I'm praying for an accommodation for today.
Whatever, I don't know.
To remain on board at the request of the council for the.
Would you like a passport or?
No, you want
not for
passport?
today. Not for today, my lords.
All right, whatever, I don't know.
At the request of council for the respondent to remain on board.
Yeah.
The appeal is not taken up for hearing today, to remain on board.
It will remain on board. Great.
Also, the LR application is defective in 103.2.
I don't
103.2 R2 died and the LR application is defective as per the office report. Whoever needs to take steps.
Who does it do?
Please take steps.
Thanks.
The in 103.2 mentioned
Who's
the
matter?
application filed for Indian Record legal representatives of respondent number 2 is lying under effects.
Please, my
Not
lords.
whether the steps have been
But
taken.
you have to make the amendment that you have defective, that's all, we'll allow it. We have got no difficulty. Or if there is no objection, we can allow it, even if they are defective.
My lords, no objection. The parties are the same.
Right. In 103.2, you record this. Also appearing for the legal representative of respondent number 2 says that they have no objection. They are treated as legal representatives in this appeal. In view of the statement, we allow the present application
Yes, sir.
and take the amendment with more parties. Or
You think
What?
that also, no?
abatement, if any, is set aside. Yes, please.
It's 104, Mr. Ramchandra is appearing on the opposite side. Means I seek an accommodation for this week. The AOR and the arguing council, it's both are down with.
All matters we keep on accommodating.
It's both our AOR and the arguing council, they're down with viral fever. Means only for this week. We've already informed the other side also yesterday.
In view of the request for adjournment made on behalf of us for the respondent, the appeal is not taken up for hearing today. To remain on board.
Published.
105 should be, indicated if there's a possibility of a settlement. You have to still seek instruction because
Manoj may have it after some time.
there's a
Just state that there is possibility of settlement. The appeal is not taken up for hearing today. To remain on board. You want it?
may have it in January then because it's second week of January possible.
The appeal is not taken up for hearing and will be to be re-notified in the third week of January 2025.
Bless.
Right.
Yes,
106 was mentioned yesterday, my lord. For accommodated for traders. 106.
My lords, in fact, in 106, my lords, we are led by the learned ASG.
The appeal is not taken up for hearing today.
My lords, could it be next week? My lords, we are led by the learned ASG. She's in some personal difficulty.
Then tomorrow it won't come up.
Oh, very well.
Next week probably we'll have a miscellaneous week.
Very well.
It may come up in January.
Very well. Great.
Now in 107, we have the advantage of two judgments of this court which we believe cover the issue. Your Lordship will note that there is an order of this court itself on 19th of January 24. Your Lordship will just see the order sheets. 19 January 2024.
19th January.
In this appeal. There were two sets of contesting respondents. One is Haryana and one is Gujarat.
Yes.
The matter regarding Gujarat got recorded as settled. Please see the order of this court on 19 January 24. Your Lordships have it?
Yes.
So I'll just read it. In terms of the signed order, as the disputes have been resolved and settled between the appellant Adani Power Limited and respondent number 4 GUVNL, that's the Gujarat entity. The present appeal interstate the said parties will be treated as disposed of. Correct? So, qua Gujarat, it is now over. Now, it remains in relation to Haryana.
Yes.
Now, as far as Haryana is concerned, and here I'll request the courtmaster to just hand over IA 59927 of 2024. And my learned, I'll just state my point and then my learned friend can respond. According to us, this is fully covered inter partes between the parties. And as far as the appellant is concerned, we have succeeded. And therefore, this impugned order deserves to be set aside and reversed. It's this, in respect of the very same PPA.
Not if I may permit me, my lord. As between the inter parties, my lord, it has been settled on that particular issue, my lord, where the station trade.
Yes, station trade.
Pardon?
It is settled, my lord, by an earlier judgment of your lordships, my lord.
So I haven't gone through the judgment. I'll be very frank. I've not gone through the.
So I'll just explain it to you. There is an issue. There was.
Just give us a citation. I'll just.
Yes, Manoj, I've placed them both before you in IA 59927.
Okay.
Your Lordship have it?
Let's keep it next week or whenever it comes up. Let me just go through the judgment.
All right. So
only one submission, my lord. Only one issue, my lord, arises out in this.
There is some issue which is still subsisting.
There are a number of issues decided in the other matter, my lord. That issue relating to the station trade has been settled.
Regard to
station trade, my lord.
Station
trade in a thermal power station, my lord. What it should be, whether it should be bid assumed parameter or whether it should be as per the tariff regulation.
No, because I remember when we had passed that order, even in the other matter with regard to Gujarat, there was some confusion.
That's not the.
Now that's
which is
settled and over,
by
Manoj. Now
compromise.
let's not reopen
There was
that.
some confusion also at that
No,
time.
no. Anyway, I wasn't there on that day, but possibly that chapter is over.
Gujarat was through a curative procedure, my lord, there was a compromise arrived at. That's a
There was
different.
some confusion.
Yes.
I don't remember, but apparently it was told once and then it was decided.
Yes.
But the same judgment.
So what is the issue here?
Lord, there is a element of station entry which determines the quantum of code
Look, we
required.
couldn't have gone through all the flow. What is that issue?
I thought it was the same time.
Station E-Trade.
Yes, Lord. Lord, this is the competitive bidding process, my lord, by which the Adani was selected to generate electricity and
consumption of coal.
There's some formula with regard to consumption of coal and generation of electricity.
Yes, Lord. The quantum which is required to generate electricity would also depend upon the station heat rate of the machine or the thermal power station. Whether station heat rate should be 2341 or 2384, etc., Lord, is decided by the commission, Lord. They are in a 62 proceeding. In a 63 Lord competitive bidding process, it is Lord the bid is assumed on a particular station heat rate. The issue arose, Lord, whether for the purpose of change in law, when a change in law occur and more coal is required for that particular purpose, whether the station heat rate should be as per the bid assumed parameter or whether it should be by the tariff regulation or actual, which is less. In the earlier judgment, Lord, relating to Haryana and Adani itself, for some other aspect, Lord, the station heat rate has been decided. It should be tariff regulation or actual, whichever is less. Lord, here, Lord, the impugned order, they have said, no, it should be bid assumed parameter. Bid assumed parameter. Therefore, Lord, I can't, Lord, as a Haryana, when I'm paying them, for one purpose, I can pay on a particular station heat rate, and for another purpose, I pay on a station heat. Lord, it's not workable at all. Therefore, Lord, Lordship can follow that judgment, Lord, earlier.
To be frank, this is a technical matter. We are not so familiar with it.
Shall we
Covered, Manoj, absolutely covered. Same PPA, our court.
Yes. Let's just go through the judgment.
Certainly. So may I then just assist the court?
Yes.
If your lordship,
paragraphs you want us to read?
Yeah. Sorry. Your lordship has IA 59927.
Yes. Or you can make us go through that. If you can explain what is the issue, because
I can explain the issue now, or I can give your lordship the paragraph numbers of the impugned judgments, and you can study it. Whatever. It's a very narrow issue. It's a very short issue. I can do it now if your lordship allows us. Whatever the court is comfortable.
Just tell us the paragraph numbers.
Yes. All right. So your lordships have a judgment of our court at page 8 of the IA.
Yes. Yes.
It's the citation at the top is 2023 SCC online SC 461. Your lordship has that?
Yes.
So please note, according to me, the relevant paragraphs are paras 20 to 23. There are certain other paragraphs as well, but I thought I'll just give you the focused paragraphs, right? Then there is a second decision, which your lordship will find at page 20 of the IA. Report is 2023 7 SCC 623. Your lordships have that? So may I give you the relevant paragraphs? According to us, it is paras 17 to 20.
17 to
20. And the third judgment is 2023, page 30 of the IA. Page 30 of the IA. Citation 2023 7 SCC 401.
Yes.
And here, your lordships may just note that the relevant paragraphs, according to me, are 118, 120, 121, and 137.
118.
118, 120, 121.
137.
And 137 to 139. So whatever, we can All right, my learned friend also correctly relies on para 151. So, of that
139 to
137 to 139, and then the conclusion in 151. 151.
To be listed, not appeal is not taken up for hearing today. To remain on board.
What do you want to do? Electronic record.
And the state of Karnataka?
3 states.
So this will not take it up in this page because
We will also list it on some date for directions, so that there's a set of cross SLPs, cross appeals, cross appeals.
not the appeal or suit.
No, this is arisen from 136 from Tribunal Award.
Okay. The appeal is not taken up for hearing today. List for directions in the third week of January 2025.
Very well.
Please, before the respondent state, I don't think anything survives in this matter. This was in relation to the appointment of a vice chancellor under the Maharashtra Universities Act 94. Now that act is repealed, these appointments are over. 2016, there is a new act in Maharashtra Public Universities Act 2016. The procedure is different now. Unless for academic, even the petitioner was not a candidate in any of these proceedings. So unless academically, if you are deciding this question, then I will get ready in the matter.
It's the impugned order, Your Lordship, which is under challenge, which lays down the findings that the UGC regulations are recommendatory in nature and they're not binding on the state government. Now, what they have done on the relevant occasion, Your Lordships, a very important clause which says that on the search committee, while appointing the vice chancellor, there should be representation from the UGC. Now, they introduced amendment. By that amendment, my lords, they have deleted that requirement, and my lords, they have appointed the vice chancellors. That was under challenge before Your Lordships. In the meantime, my lords, during the pendency of this petition, they have amended it, Your Lordships. Even the UGC regulation amended to some extent, giving power to the state government to constitute a committee as per their choice, my lords. And my lords, the act is also in 2023, they have amended Maharashtra Act. Now they have added one of the member of the search committee as been nominated by the UGC. But my lords, so far as the UGC regulation 7.3.0 is concerned, which also talks about that there should not be any representation on the search committee of the person who is connected with the government. Now that remain as it is, Your Lordship. So this will not become infructuous so far as that point is concerned, because the secretary.
But that guideline has been withdrawn or not withdrawn as of now?
Now there's a new act.
Okay, UGC Act is gone.
No.
Maharashtra, the UGC Act remains. It's not. There have been talks about. Haven't they done something about the UGC Act? Of law open and take it up in a, because he is not interested in that answer today.
But so far as the findings recorded in the impugned judgment,
You can take it up before this court directly, that arises. Committee to raise it.
The findings which says of this.
No, we will not, we cannot upset the findings, we cannot set aside the findings or the ratio, but we'll permit you to raise it before this court if it arises. Because he is not interested in fighting it out.
Let's put here with respect, Your Lord.
Academic purpose, if you have to fight out my lord,
it's a very very important question.
No, we understand that.
Because the High Court says,
look, please, look, we have enough work. I think it's on our hands. Right.
Because he is not a
candidate. Of the subsequent developments, including enactment of
New Act.
New Act is Maharashtra Public Universities Act 2016.
Maharashtra
Public Universities Act,
Public Universities Act
2016.
2016. Several legal issues raised in the present petition are not alive and do not require adjudication. Most of the legal issues are not alive, do not require, I would say most of the legal issues, any adjudication. Most of the appointments in question have also worked themselves out. To stop. In these circumstances, we are not inclined to go and undertake an academic exercise and dispose of the present appeal, making it clear that the petitioner or any other person, if deemed appropriate, may take up the legal issue with regard to compliance of, which is the guideline?
UGC regulation 7.3.0.
Non-compliance of the UGC regulations. What is the name of the regulation?
UGC regulation 7.3.0 was the relevant regulation.
7.3.0. 7.3.0. Which page?
Regulation on minimum qualification for appointment of teachers.
Which page is it?
Page F of Civil Appeal number 1973.
UGC regulation of 2010.
Second paragraph.
UGC regulation
on minimum
laying down regulations of the UGC regulations on minimum qualifications for appointment of teachers
And other
academic staff in universities and colleges and measures for maintenance of standards in higher education 2010, and in particular regulation 7.3.0 in an appropriate writ petition. If any such writ petition is filed, the same would be considered and decided in accordance with law. Liberty is also granted to the said party to directly approach this court if required and necessary.
Please.
Recording of posted, the appeal is disposed of.
In item 110, the trial court records are received in the registry. Lordships will have to direct the registry to provide us.
Not got the trial. You got the trial court records?
We don't have it, Mullah.
No, I filed the evidence that I am relying upon.
What is this? Not filed the entire evidence?
It's there. I filed almost all the
becoming
evidence.
Selective in even filing evidence?
No, I'm not selective, my lord, but I filed whatever the evidence I am relying upon, my lord. They've been filed since the time notice.
We have received the trial court record. You're not ready.
We have not received it. It will require a direction by your lordship.
E-copy of the trial court record. When was it received?
When will it be office report?
Date is not given.
E-copy of the trial court records will be made available to the counsel for the parties to remain on board.
I'm grateful.
Milord, will it be coming? I just don't mean to ask in that way, Milord, but I believe there are certain changes about
yes, it is probably in January it will come.
But then your lordship's last order of 511. Please consider it only for the interim part, Milord. I'll be here. I will argue. There's no doubt about that, Milord. Please take my word. I'll be here to argue it. On interim, for 2 months, there is a child. The reason I'm saying there's a child, the mother is there.
If I'm not mistaken, this is the same case in which you're taking
yes, so I'm here today, Milord. I'm here. In July, I wasn't here. And therefore, I'm...
But the other side is
now the other side. So I'm not at fault. Milord, there is a child.
The records were received in 2022. What are you doing since then?
Since the matter was not on board,
it was listed several times after that. Order dated 24th January 2022 records that the
records were. Please take it from me. He's been and I'm acquitted of 304B, 498A, and there is medical evidence is wholly lacking in this case. Well, it's a clear case of suicide. I've been convicted under 302. And there's a child who's 10 years old now. The mother is not there. And there is a...
We can convert 302 into 304B.
Yes,
That's
brother.
how we have.
Undergone. Please do it on undergone. I say it now only. Please do it undergone. 7 years more than I've undergone. It's punishable with some years. Please do it immediately. He's that... he doesn't mind the conviction part of it at all, my lords. He doesn't mind it.
Then 302, you should.
302, 304, lordships may do it, my lords, but he's only praying, my lords, that he and
Wait. How long have you been inside?
more than 7 years, 7 years, 6 months, 29 days.
302 can go up till 304B goes up till 10 years?
Yeah, it starts with 7, which is minimum, no doubt about that.
Can go up till 10 years?
But I'll get some remission. I'll get some remission part with it. Unlike the life sentence, my remission is more in the.
Okay, wait, just wait.
That's great.
What should be?
The cross appeals, my lord, sir.
Yes, please.
Karnataka High Court has taken a stance. Allahabad High Court.
My lords, I appear on behalf of the petitioner. The arguing counsel is on his
Please,
left.
let's start with some matter. Let's start.
The arguing counsel is on.
Take the opportunity. Start. Please.
My lords. My lords, may pass it over.
Who starts, sir? Who is not served? Is he a necessary?
This is with regard to the
Yeah, that matter.
5876.
general matter.
In the other two matters,
Mines and minerals must be
wanted to file an
with regard to the transportation of mines and minerals.
Fees imposed by the state for mining.
We'll give you a pass.
My lords, may grant an adjourn.
Brother.
God is only on one side. He's the only one on one side. You all
No, because in Karnataka High Court has taken a view contrary to what has been taken by
UP.
No.
But this was earlier. Everybody was pressing for the hearing of this.
Yes, and it was there.
They were saying why the trucks, etc., are passing through and they're being charged, make it economically unviable. Today, nobody's there to press it. There in the other second court, I was repeating.
Yes, they are.
Asked, please take a cup out of turn. Remain on board. At the request of the applicant, it is not taken up for hearing today to remain on board. That's that matter.
Mentioned by Mr. Datta, Lordship में But I don't think it should take more than around that. Afterward, all has been argued.
So you have taken the instructions, etc., on that part.
No,
And who's up in for the other side? That Mr. Sood was there probably. Ashish Sood.
Board has he may not be here.
Should we keep it for tomorrow?
Tomorrow, Mr. Datta has some difficulty. Lordship,
afternoon.
next week,
Recipe
someday in the afternoon.
Recipe.
We are also have to constitute a separate bench.
Board.
Obliged to the.
Yes. I really am not mad.
But I'm appearing for the appellant.
This is
Look, the three substantial question of law. If your lordship would kindly see the order dated 13/10/2022.
Yes.
While admitting the appeal, my lord. You can hand it over. Copies the. Here it is. These 3 copies. So when we come to the operative portion, Lord, after discussing the issues.
Please tell us the issue in question.
But the respondent, my lord, is a generating company. They are appearing for the distribution company or the company which purchases the power. The agreement relates to, my lord, 1996. The question, my lord, of 3 issues of tariff element, my lord, a depreciation, rebate, and foreign exchange variation, rate variation, and a sinking fund to be created for the purpose. The depreciation, my lord, in our submission is admissible, my lord, as per the statutory notification for up to 90% of the project cost, excluding the value of the land, leased assets, etc. In the order, my lord, they've allowed much more than the 90%. It comes to about 107, 108%, which involve, my lord, outflow of more tariff from the distribution company. Therefore, the consumer will have to pay the more tariff. In regard to rebate, my lord, despite the regulation providing for the rebate to be allowed, my lord, on the basis of even part payment. If I make an early part payment, I'm entitled to rebate. They've construed it, my lord, saying that there were other dues which you did not pay, therefore the rebate is not admissible. Sinking fund, my lord, they were to create it. Again, my lord, the appellate tribunal comes to the conclusion, since there was some default in my payment, making payment of some other dues, my lord, therefore they didn't create the sinking fund, and therefore they should not be visited with any consequences. These are the 3 substantial questions of law, my lord, which has been framed at page 9, my lord. We have circulated a list of date and the note of submissions, my lord.
Just read out this order.
Yes. In our view, if your lordship has, after discussing the factual aspects, in our view, the following substantial questions of law do arise for consideration in this appeal. Where is it now? Whether depreciation has been allowed over 90% of the project cost allocated to the appellant shares, and hence is contrary to the statutory notification dated 30th of March 1993. It should be 1992, but whether the supplementary agreement dated 18/12/2003 altered the approved project cost under the PPA dated 30/5/1996, and in any event, whether this supplementary agreement with regard to depreciation was not novated by the subsequent agreement contained in the letter of respondent number 2 dated 22nd September 2004 and accepted by the appellant by its letter dated 8/10/2004. Whether the creation of the sinking fund was not the prior reciprocal promise to perform before demanding compensation through foreign exchange rate variation from the appellant. Third, Lord, whether the consideration of the appellate tribunal in relation to the question of rebate suffers from an error apparent on the face of the record when the appellate tribunal observed that the claim of the appellant disputing previous invoices was an afterthought, or that the appellant did not deny that the procedure prescribed in Article 5.4 of the PPA for disputing the invoices was not complied with. Then, Lord, whether the appellate tribunal has heard in applying only clause 5.3.2 of the PPA to enable adjustment by the respondent, number 2, despite the dispute raised by the party, then brought as regards all this. These are the questions of law which has been framed for consideration.
Yes.
Lord, if your lordship would kindly come to the list of dates, Lord, that would probably, yes, circulated, Lord, the list of. Lord, yesterday it was circulated, Lord.
Yesterday?
Yes.
Respond. So it's in the file cover.
But I believe in the file cover, Lord.
This was not there.
Yes.
Yes. Lord, may I quickly take your lordship through the list of days, Lord. Gujarat State Electricity Board, the predecessor in interest of the Gujarat Urja Vikas Nigam Limited, entered into a power purchase agreement, Lord. And this power purchase agreement, Lord, that 4/5 line, at the relevant time, the statutory notification dated 30th of March 1992 of the central government, notified under Section 43A of the Electricity Supply Act, governed the PPA in regard to the tariff terms and conditions. Therefore, the PPA has to be read along with, Lord, this statutory notification, and PPA also says so, Lord. Then, Lord, 1/6/1996, the gas turbine of SR Power Project, 3 in number, were commissioned and the open cycle operation of the power plant commenced. August 1996, in terms of Schedule 7 of the PPA, SR Power had provided to GEB the details of the financing plan for the power project. 12/3/1997, GUVNL wrote to SR Power dealing with the financing plan, means of financing of the power project, and raised certain aspects for clarification and compliances, including on the aspect of depreciation admissible. Letter from the SR Power to GEB providing the clarification and compliances in respect of the financing plan limited by submitted by SR Power, including as to the project is the aspect of depreciation. Then Note 6, 10/9/1997, GUVNL approved the financing plan of the SR Power inter alia on the basis of depreciation shall be computed on the basis of depreciated project cost. This is an important aspect, Lord. To the negotiated project cost for GEB's allocated capacity of 300 megawatt shall be 945 crores inclusive of working capital margin. Further, SR Power was required to create a sinking fund towards liability for external commercial borrowing. Then Lord, the steam turbine also gets commissioned, Lord, on 1/10/1997. Lord, the entire project by that time, Lord, 1/10/1997 has been commenced. 6/10/1997, letter from SR Power giving certain clarification and confirmation to GEB regarding the approved financing plan. It was stated that the cost of the project after adjustment is 957.78 crores. The total depreciated project cost for 515 megawatt was worked out to rupees 1588 crores. The rate of depreciation applied was 7.96%. Total depreciation for the project cost was rupees 126 crores, and qua the allocated capacity of 300 megawatt was 78.63 crores. These were all worked out. SR Power also confirmed that sinking account will commence from March 1998 and shall be funded at the end of every 6 months in US dollars. Then SR Power raised the invoice for generation and supply of power by GUNL for the month of July 1997. In the invoice, SR Power stated impact of foreign exchange variation shall be billed separately. Then 6/7/1998, GUNL's letter to SR Power regarding computation of the fixed charges to be part of the to be paid by GUNL during the open cycle operation of the SR Power plant. Then 18/12/2003, supplemental PPA amending certain provisions of the PPA dated 30/5/1996 executed between the parties as per the settlement reached. It was stated that the depreciation for the period 1st July 2003 to 1st July 2000 shall be 2010 shall be paid at the rate of.
You put a W there. Is it 2010?
10, my lord. That W is 0.
But it doesn't coincide with the financial year.
Yes. No, it doesn't. In this case, my lord, 2010. There is a reason for that, my lord. Shall be paid at the rate of so and so. Then, my lord, 19/12/2003, letter issued by GEB along with the supplementary agreement signed on 18/12/2003 regarding the settlement reached on some of the outstanding issues during the negotiation. 14/6/2004.
This is 2013.
My lord, your lordship may correct it, my lord, as 2013, my lord, not 10. 2013, my lord. That W.
W is 2013.
13. Then 10 years, my lord. The letter from SR Power to GEB in respect of GEB's letter dated 19/12/2003 dealing with the aspect of the settlement. Then, my lord, kindly come to the 29/2004 letter from SR to GEB making claims in regard to admissible depreciation. SR Power confirmed that the depreciation amount to be paid over the life of the PPA should be limited to 90% of the project cost allocated to GEB. That was the 957 crores. Then, 18/8/10/2004, letter from GEB to SR Power disputing the claim of SR Power and working out the depreciation cost of the allocated capital cost to GEB at rupees 957.28 crores at 26.39 crores instead of 40.85 crores mentioned in the supplemental PPA dated 18/12/2003. The detailed worksheet was attached to the letter. In the said detailed working, GEB had set out the project cost for 300 megawatt at rupees 957.82 crores, and after reducing the value of the leased assets and land, the depreciable project cost is worked at 862.69 crores, on which depreciation is to be computed up to 90% of such cost up to 766.42 crores. The said details also provide for normative depreciation from 1996-97 till 30th of September 1997 during the open cycle operation of the SR Power project of rupees 0.43 per unit and an amount of rupees 36.82 crores and rupees 24.58 crores aggregating to rupees 61.440 crores till from 1/1/10/1997. Depreciation was on the combined depreciation was on the combined cycle operation for the period till 2001 to it was 73.64 crores on basis. The table also shows that the remaining period of depreciation should be rupees 26.39 crore to cover the 90% depreciable project cost of 776.42 crores. Letter from the SR Power, from SR Power to GEB, claiming non-payment of the depreciation as per the supplemental PPA, and the same is affecting the ability of the SR Power to create the sinking fund. Letter from SR Power to GEB inadvertently left out in the separately the document is available. The effect that the depreciation is to be computed on rupees 925.18 crores. Well, that's a controversy, Lord, is whether it should be 925.18 crores or the 852, etc. Lord, which way. And depreciation.
That's the primary controversy.
Yes. That's the first issue.
So this difference is arising on account of?
Yeah, this difference is arising out of, Lord, they claim the total project cost to be 1,765. Whereas
1,765.
Yes, Lord. Whereas, Lord, with reference to 300 megawatt, in the negotiation, they have clearly agreed that the project cost will be 957.82.
957?
78 crores for 300 megawatts.
According to you, that project cost cannot undergo a change.
Yes. The total project cost as per the 957.82 crores will come to about, for 515 megawatt, it will come to about 1500 megawatt, 1500 crores, that 1500 crores. This is the controversial, Lord. If the depreciation is calculated as per 957.78 megawatts, 78 crores, then, Lord, our position is clear, Lord. We have to pay depreciation as per our calculation. They say that only for the purpose of depreciation, it should be on the basis of a higher project cost, whereas not all the other tariff element like interest on equity, interest on loan, return on equity, everything is calculated admittedly at 957.82 crores. Yes. The other controversy, Lord, on the depreciation is when we arrived at a supplemental agreement setting out all the various dispute, Lord, one of the entry there was depreciation for the future will be calculated at 40.84 crores per annum. Whereas, Lord, that was an inadvertent, that's what we have pleaded, inadvertent mistake. We immediately sought to correct it, that it should come to 29 crore. And therefore, Lord, if you calculate it at 29 crore and take the 957.82 crores, the 90% depreciation stands fully paid to them. Whereas they say it should be 925 crores, and this is not an inadvertent mistake. And they are raising also, Lord, lately, saying that during the open cycle operation, the first 2 years, Lord, no depreciation is to be adjusted. These are the three controversies, Lord, which I'll point out, Lord, on the aspect of the depreciation. 18, Lord.
Yes.
Item 18, 15/10/2004. Letter from SR Power to GEB, sorry, I read it, Lord. 19, 21/7/2005. The government of Gujarat decided that the dispute, Lord, I'm avoiding the other various things, Lord, which may not be relevant. We went to the government of Gujarat, negotiation, etc. The government of Gujarat finally said, you go to the Gujarat Commission with all the disputes between the interest between the parties. 20. 3/8/2005, letter from SR Power to GUNL raising delay in the repayment of loan by SR Power due to non-fulfillment of various conditions specified by the lender and seeking to source finance through short-term basis. 21. 6/8/2005, letter from SR Power to GUNL raising several claims against GUNL and stating that all the claims are to be referred to arbitration under the bilateral arbitration clause contained in the PPA. Then at 17/9/2005, letter from GUNL to SR Power raising issues on the monthly invoices raised by SR Power. Then Lord again raised dispute raised 13/10/2008, Lord, that arbitration reference came up to the Honorable Supreme Court. The Honorable Supreme Court, Lord, decided in the juvenile versus SR Power case that all these matters cannot go to bilateral arbitration. It should go to the State Commission under the Electricity Act, Lord, under Section 86(1)(f) of the Electricity Act. Then, Lord, 25, SR Power filed a petition on so and so before the GRC, raising various disputes and sought adjudication. Then, Lord, this petition was heard on 20th of April 2013. It was reserved. Then, Lord, 22nd of October 2014, order was passed by the GRC. And, Lord, the three aspects, Lord, which are discussed, Lord, I go to the order, Lord, at the relevant depreciation aspect, sinking fund, and rebate, Lord. These are the three aspects.
1 minute. Depreciation, rebate, delayed payment surcharge,
yes,
foreign exchange rate fluctuation, sinking fund.
Yes, yes. It's not really delayed payment surcharge, my lord. Non-creation of sinking fund. If the sinking fund had been created, my lord, the variation in the foreign exchange would have, it's like a hedging the variation, my lord, that would have been paid through the sinking fund. The sinking fund was to be created, my lord, under the financing plan. These are the things, my lord. Then the appeal was filed, my lord, by us, my lord, before the appellate tribunal. The impugned order, my lord, was decided various issues, my lord. On this, the depreciation, foreign exchange, and rebate, my lord, has been decided, and we have filed the appeal, my lord, in which the three issues of thing has been framed, not the substantial question of law.
How does foreign exchange, etc., come up for consideration?
Yes, Lord. What happens, Lord, in the financing plan? If they are funding the project cost through external commercial funding, that by taking, Lord, the foreign exchange, there is a risk of the exchange rate going up.
Correct.
In order to, Lord, hedge that the foreign exchange variation, Lord, internally they fund it through a sinking fund, Lord, whatever over a period of time, Lord, out of the earnings, etc., they put it into a sinking fund, and the exchange rate variation is partly met by the sinking fund, so that it doesn't come as a liability to the procurer, Lord, and thereby to the consumer. That's, Lord, they ought to do it. They did not do it. They blame us, saying that we did not pay them the regular bills, etc. Therefore, they did not do it. If they have done it, Lord, that foreign exchange risk would not have come on us to that extent, Lord. The foreign exchange.
They had to do the hedging. They did not do the hedging.
Hedging in the sense of putting the fund into a sinking fund and keeping it and to pay Lord, the foreign exchange rate variation. I'll point out, Lord, the financing plan on that.
And there is a specific clause dealing with regard to sinking fund for foreign exchange fluctuation.
Yes. That
and what is about that delayed payment surcharge is that they are asking you to pay the
delayed payment surcharge is that I did not pay that bill. Their allegation is I did not pay that bill
within time, and therefore
there is a delayed payment surcharge. Since I did not pay the delayed payment surcharge, they didn't have the fund to create the sinking fund. This is what that.
Okay, let's see the order of the.
Yes. Would the Lordship first go through the tribunal on?
let's, should we go to the judgment or the clause, relevant clauses of the PPA first?
Lord, if your lordship put for a second, Lord, if your lordship would see the
second note
table along with the notes of submission, Lord, just to give the
summary of it.
Summary of the depreciation, Lord, issue.
Yes.
And immediately, my Lord, I move.
Note of submissions.
Yes. Page 10, my Lord, last page. Lord, that last two columns, Lord, one is as per SR power, which is the respondent, and as per GUVNL, the appellate, Lord.
Yes.
Depreciable project cost for GUVNL share of 300 megawatts, according to SR power, Lord, 925.15 crores. According to GUVNL, Lord, 862.69 crores.
Yes.
So, Lordship would say, 90% of the depreciable project cost, according to SR power, comes to 832.64 crores. Lord, 10%, as your Lordship are aware, Lord, is not allowed as a depreciation because it can be salvaged through residual valuation, etc. That's a provisions of the Act itself, Lord. The 832.64 crores, according to us, Lord, 776.42 crores. Payment made till signing of the supplemental agreement, we have, Lord, paid 486 crores. They calculate only 424.15 crores. That's a difference. Difference, Lord, is 61 crores. That 61 crores, they say it relates to open cycle operation, and no depreciation is payable, is admissible during the open cycle operation. According to us, Lord, it is admissible because the assets are being used to generate and supply electricity, and our chart will show, Lord, how it has been paid also. Balance depreciation, Lord, is, Lord, according to them, it is 408.49 crores. According to us, 290.16 crores. This balance depreciation is to be recovered, Lord, over a period of time, Lord. That is the next column. Depreciation payable per annum with effect from 1/7/2003. Effective date of the supplementary PPA dated 18/12/2003, Lord, spread over the PPA terms. According to them, Lord, it is 40.8485 crores. According to us, 29.02 crores. The next, Lord, the note under that, Lord, the calculation of 862.69 crores as per GUVNL for GUVNL's allocated capacity, the project cost is, Lord, 945 crores, which was, Lord, adjusted to 957.82 crores. Then reduce the cost of land, cost of leased asset, it comes to 862.29 crores, which is, Lord, the first entry in the earlier table. Then, Lord, calculation of 925 crores as per SR is, Lord, project cost qua the total capacity being except 1768 crores. They reduce the lease land, etc., make it as 1588.918 crores. And our share, Lord, the 300 megawatt, they have calculated it on 925.15 crores. These are the areas of the controversy, Lord, as far as the amount of rupees, etc., etc. The amount of rupees 486.26 crores paid by includes, Lord, all.
Service finished, we always reissue.
I point out, Lord, the first is statutory notification. Lord, before I go to, Lord, the impugned order, kindly see the statutory notification, Lord, which is kindly come to volume 2. Or there's an application for additional documents. Page 10, my lord. Page 10. Page 10. Or this notification has been issued, my lord, under the erstwhile Electricity Supply Act.
Yes.
That's given, my lord, in page 10. Under section 43 capital A of the Electricity Supply Act, therefore, my lord, it statutorily binds all the projects, my lord, and kindly comes to page 21, my lord. That is on the depreciation.
Yes.
2.6. The annual capacity charges shall be computed on the following base, namely,
Page
interest of
22.
21 before flowing to 22, my lord. Part explanation 1.
Yes.
The total of depreciation, including advance against depreciation charged through the tariff, shall not exceed 90% of the approved capital cost during the life of the project. Make one's approvals.
First part of it.
Interest on loan, return on equity.
The rates of depreciation applicable as notified by the central government from time to time or advance against depreciation shall be applicable at the annual amount. That
Well, there's no dispute on that.
There's no
Only give an
only the explanation is this.
Yes, sir.
So the three terms are approved cost, capital cost.
Yes, sir.
During the life of the project.
Absolutely. But what happens, Lord, irrespective of what
the term approved project cost has been defined?
Yes. Yes. If not, I'll point out, Lord, where it comes. Irrespective of what they incur as a project cost.
The approved project cost will be the actual.
Yeah, the approved project cost will be what should be considered for the purpose of tariff. During negotiation, they can reduce it. Whatever it's not, but what is finally bilaterally agreed.
It's not the actual cost, but the approved project cost.
Absolutely, absolutely. But here there are 2 or 3. The depreciation, your lordship has come across the expression advance against depreciation. Depreciation spread over the life of the power plant, which is 25 years, my lord, will come to about 3% only. But depreciation is also to enable, my lord, to them to fund the project, to borrow money. Therefore, Lord, the depreciation is staggered in 2 parts. One, higher depreciation for the first 10 years or so, for 6, 7, 10 years. So that, Lord, the repayment of the loan to the lenders is facilitated out of the depreciation money, although both are not related, out of the depreciation money. Therefore, Lord, your lordship has seen, Lord, one is 7.90 rate with the initial period, then it gets reduced to 4% of the depreciation on the 90% of the approved project cost minus, Lord, the land value and the leased assets. That, Lord, if your lordship put, I've seen this one, Lord, if your lordship put now kindly come to the PPA provision.
Yes. Which page?
If your lordship would kindly come to the, I'm sorry, Lord, page 12 for a minute, Lord.
Is the term approved project cost defined in the regulation?
Yes, it is referred to, Lord. It's not defined as such, but if your lordship would kindly come to page 12.
Yes.
1.2.
Yes.
Yes. Where is it? Page 12, Lord, sorry.
Yes.
Yes. 1.2, Lord, the capital expenditure of the project shall be financed as per the approved financial package set out in the techno-economic clearance of the authority, the project shall include capitalized municipal charge, etc. Kindly come to Lord. Then next is actual capital expenditure incurred or on completion of the project shall be the criteria for fixation of tariff. Next, proviso, Lord. They provided that such excess expenditure is not attributable to the etc. Next is important. Provided further that where a power purchase agreement entered between the generating company and the board provides a ceiling on the capital expenditure, the capital expenditure shall not exceed such rating. Therefore, my lord, irrespective of the actual expenditure, once we agree under the power purchase agreement a particular capital cost, that would be the governing capital cost.
Page 160 in the PPA.
Yes. Now, my lord, if your lordship would kindly come to the power purchase agreement, my lord, page 160, the same volume, my lord. Page 160 is a relevant class, my lord. 7.4.1, bottom page, my lord. Capital cost on the allocated capacity. Lord, the word allocated capacity is used, Lord, because out of the 515 megawatt, 300 is allocated to me. I'm concerned with 300. 215, they are selling it to their own sister concern. I'm not concerned, Lord, what the project cost they have agreed to with the sister concern. For allocated capital cost, Lord, this is capital expenditure of the allocated capacity, that is 300 megawatt of the generator station, shall be financed as per the approved financing plan. The cost of the allocated capacity shall be 945 crores as per the approved financial plan. Lord, 945 had become Lord 957 crores because of some adjustment in the foreign exchange rate and for borrowing, Lord, which was put out. That's not in dispute, Lord. As regards the leased asset, the same shall be included in the capital cost for the purpose of computing the O&M expenses, but excluded for computing depreciation. Yes, sir. Lord,
yes.
Now, Lord, depreciation is dealt, Lord, at page 153 in the PPA.
Page?
Page 153.
What is the date on which the regulations came into force?
That's 30th of March 1992, Lord, much before.
Much before. So everybody was aware that these regulations will be applicable.
The PPA itself says you are bound by those. I'll come back to it.
Yes.
See.
Page
153. Depreciation. Depreciation will mean the depreciation as notified by the Government of India from time to time and provided under the Electricity Supply Act 1948 and shall be first computed on the assets of the generating station and thereafter apportioned for the purposes of determining the annual fixed charges as a proportion of the allocated capacity over the nominal installed capacity. The nominal installed capacity is 515 megawatt. Allocated capacity is 300 megawatts. The 300 megawatts, my lord, is what apportioned allocated capacity to me, on which, my lord, the depreciation has to be calculated. That was 957.32 crores. Then, my lord, if your lordship put that notification. Notification under the binding. PPA. Yes. Lordship put yes, that's fine. That's the date. Lord, if your lordship put Lord, we are the act, Lord, the parent act which governed at the time, Lord, as the Electricity Supply Act, Section 43, capital A of the Electricity Supply Act, Lord, provide for Lord, the tariff issue, how to be determined. The 43, Lord, clearly talks about, Lord, the notification to be issued by the central government. And under the 43A, Lord, the 30th month, I need not refer to that, Lord, I'll put it separately, I'll give it to you, Lord. the governing principles which has to be done. 30th March 1992 notification, my lord, was an entire governing principle binding on both the parties by which, my lord, the tariff is determined. Equivalent to, my lord, any tariff regulations which has been framed, my lord, after the Electricity Act has come into force. Therefore, my lord, the 30th March 1992 notification is, my lord, a subordinate legislation, my lord, which governs the entire parties. Now, my lord, if your lordship, on this basis, if your lordship would kindly come to the decision of the appellate tribunal, my lord.
In the PPA, where do we get the computation with regard to the project cost?
The computer, I've read the element, my lord. Your lord.
No, that we went through that, but PPA doesn't.
My lord, let me, my lord.
Where's the project cost?
Kindly come to page 36, my lord.
36.
Yes.
Yes.
Yes. Yes. Kindly come to 36. Capital cost shall have meaning specified in Schedule 7 of this agreement. Schedule 7, my lord, deals with the capital.
Schedule 7 deals
at page 157, my lord.
Okay. Does the Schedule 7 also say that the capital cost can undergo a change?
No.
It's a fixed element.
No, it can go only through a change of additional capitalization, not the amount can change as such.
Okay.
Additional capital.
So, regardless of actual capital expenditure, the capital cost has been fixed.
Yes.
And that's not changeable. That's not alterable.
That's not changeable. What is changeable? Sorry.
Schedule 7,
Lord, the capital cost, Lord, is first determined, Lord, on the date of the commercial operation.
It's determined on the date of, it's not by the competitive bidding process.
No, this was not, Lord. Under 63 now, Lord, it's through a competitive bidding process and adopted.
This is prior to.
This is much prior to electricity Act.
1996 original agreement.
96.
And
That time there was no competitive bidding
No
process.
competitive bidding. Therefore, Lord,
and supplementary power purchase agreement of 2000.
competitive, the capital cost, Lord, is funded through, Lord.
Then it's determined on the date the project is commissioned.
On the date of the project is commissioned. That's why your Lordship would find, Lord, when they are commissioned in stages like this, Lord, open cycle operation, the capital cost may be less. Combined cycle operation, when the steam turbine also comes, the capital cost becomes more. The only way the capital cost can change, Lord, if the scheduled commissioning date changes on account of force majeure or some other extraneous reason, then, Lord, the interest during construction gets increased.
But in this case, the power plant which had to be constructed was for 500.
Yes, sir. There was no such issue on IDC.
There was no such.
No force majeure.
There is no force majeure.
Yes. Lord, your Lordship can proceed on the basis, Lord, they accept the capital cost, what I say, for the purpose of interest on loan and return on equity. There's no absolutely. The State Commission has also determined, Lord, everything for return on equity and loan at, Lord, the 957.82 crores. May I put it, Lord, the capital cost is, Lord, the original fixed cost, which capital expenditure which you incurred up to the capital up to the commissioning of the plant. Then it is divided into 70-30. 70 is funded through loan, 30 is through risk capital or the equity. Both are based on that capital cost.
Let's see what is the finding of the tribunal.
Yes. If your lordship would kindly, or would your lordship would first see the GRC judgment first and tribunal, which I'll first take your lordship through the tribunal and then come to the GRC, Lord.
Okay.
Yeah. If your lordship would kindly come to the tribunal judgment, Lord, on page 26, my lord. Volume 1.
Page?
26, my lord.
Yes.
Volume 1. My lord, I'm taking your lordship only for these three issues, my lord. The other issues are not relevant for para 59, my lord.
Yes.
Depreciation. The issue before the State Commission was whether SR Power should be allowed depreciation at the rate of 4084.85 lakhs, 40.85 crores per annum, as mentioned in the supplementary agreement dated 18/12/2013, or only rupees 29.02 crores as contended by GUVNL, stating that the amount of rupees 4085.85 lakhs per annum contained in the supplementary agreement was by inadvertence and by mistake. It is agreed that the crucial factor it is argued that the crucial factors
So you had agreed to 4085 earlier in the supplementary agreement.
There is an entry. There is an entry in the supplementary agreement 40.85 crores, which we point out, Lord, it's an obvious mistake. If you calculate 40.85 crores, your total depreciation which you are receiving far exceeds 90% limit, which is provided in the statutory.
So, according to you, the capital cost was never in debate.
No.
But the figure of 90% was the calculation of that figure was in debate.
Yes, absolutely. If your lordship would see, and that's the only reason that you agreed in the supplemental agreement, now you live with it. That's about that decision, what I point out. It is agreed that the crucial factor here is the project capital cost apportioned to 300 megawatt or contracted capacity applicable to GUVNL, whether it should be rupees 1016 crores or 945 crores, which was later increased to 957.82 crores due to exchange rate difference.
You are accepting 957.5?
957, yes. I'm arguing for 957.82 crores.
Yes.
The depreciation is related to the capital cost represented by the gross value of the capital assets and the project capital cost allocated to supply of 300 megawatts to GUVNL was rupees 945 crores only, adjusted for FERV component to rupees 957.78 crores as confirmed by GRC in para 11.2 of the impugned order. It is argued that since all the tariff elements for payment by GUVNL to SR for 300 megawatt contracted capacity with return on equity, O&M expenses, interest on working capital, incentive have been claimed and paid by GUVNL on the above project cost of 945 crores only, as at all time subject only to the adjustment of FERV component, there is no reason for the State Commission to have determined the depreciation in a manner other than recognizing rupees 945 crores. The appellant contends that the fundamental mistake made in the impugned order is non-consideration of the depreciation already accounted for and paid as a part of the tariff during the generation and supply of electricity in the open cycle operation, it being wrong impression that GUVNL is disputing the computation of the depreciation in the open cycle operation. The depreciation amount to be computed in aggregate over the year should be to cover 90% of the allocated capital cost, excluding land cost, qua 300 megawatt capacity contracted under the PPA with GUVNL. Per the appellant, the said amount of the capital cost to be considered is rupees 726.42 crores and the depreciation amount based on thereon for the balance period of 1/7/2003 would work out to 29.01 crores per annum and not rupees 40.85 crores per annum. By mistake, the amount of rupees 40.85 crores was recorded in the supplementary agreement. If rupees 40.85 crores per annum is considered and taken together with the depreciation already allowed in the open cycle operation of an amount of rupees 61.41 crores, the aggregate amount for depreciation would work out to rupees 894.745 crores, which would be 115.24% of the aforesaid depreciable capital cost, contrary to the basic principle on which the depreciation was to be computed. The appellant submitted that the contention of SR Power, the depreciation was agreed to be paid on the proportion of 300/250 of the actual capital cost and not on the allocated capital cost of rupees 945 crores to be adjusted with FERV at 57.78 crores is wrong, since it cannot be that various other tariff elements such as return on equity, etc. will be accounted for and serviced at the allocated project cost as per the PPA entered into, but the depreciation would alone be allowed at a much higher capital cost.
Yeah, I couldn't understand this argument.
Yes, what we are saying, Lord, once you have an allocated capital cost of 957.82 crores as the basis, it should apply across, Lord, whether any tariff element, return on equity, interest on loan, incentive, operation and management expenses, maintenance expenses.
So it should apply across.
Yeah, across. What their argument is, for depreciation, it should apply on the actual capital cost, which your Lordship has seen, about 1756 calculated 90% after excluding.
But you are accepting 957. You are not disputing.
Yeah, 957, there's no dispute. They are not accepting, I am accepting.
Earlier, it appears that you did not accept 957 also.
No.
Or you always accept.
At all time, we have agreed on 957. Okay. Absolutely no issue on 957.
Okay.
63. Upon careful scrutiny, we find that the arguments of the appellant are an attempt to wriggle out of the contractual obligation so as to deny to SR its claim under the head depreciation founded properly in the PPA, read with the supplementary agreement, which was executed after detailed negotiation between the parties and approved by the Commission. Then, Lord, they quote the Electricity Supply Act, the tariff, etc. Lord, will have to be. Then, Lord, the depreciation. Depreciation is one of the capacity charges, and which we pointed out, Lord, the annual fixed charges, part of it, 66, Lord. The material on record shows that the parties had held detailed discussions on the subject of the calculation of the amount of the depreciation in accordance with the provisions of the Electricity Supply Act 1948, and the appellant, by its letter dated 10/9/1997, had agreed that depreciation shall be computed on the basis of the project cost arrived at by subtracting the cost of the land, working capital margin, and the cost of the leased assets, and apportioned to the allocated capacity in terms of the PPA. SR, having submitted by its letter dated 6/10/1997 its calculation on depreciation to be the tune of rupees 73.64 crores per annum. The appellant accordingly paid depreciation amount of 73.64 crores per annum from October 1997 to June 2003. The total amount thus paid is 424.14 crores towards depreciation. it was pursuant to the directions of the GRC, that the appellant and the government of Gujarat had entered into a discussion with SR seeking a review of the PPA and a reduction of the annual fixed charges, the state government having constituted a first negotiating committee to discuss with the stakeholder and suggest modification to the original PPA to reduce the power purchase cost. The prolonged discussions involving both the parties and the state government resulted in agreement actuated by consideration inclusive of the interest of the consumer and uninterrupted generation of electricity, whereupon certain terms of the original PPA were revised by execution of the supplementary agreement on 18/12/2003, including the depreciation sum of reducing the depreciation sum from rupees 73.64 crores per annum to rupees 40.85 crores per annum, payable in equated monthly installments.
What is being then highlighted is that in this case, there's a subsequent contract.
A supplementary agreement.
Supplementary agreement that will override the terms of the PPA.
Yes.
That's the reason given by the
Lordship will have to see
because it appears that you had made,
yes, sir.
Initially they had made calculation of depreciation to the tune of 73.64 crores per annum.
Yes, sir.
Which then there were negotiations.
Yes.
And in those negotiations, they had the depreciation amount payable was brought down to 424.14 crores.
Yes.
So what they are saying is it's a negotiated amount today. Yes. And therefore, if it's a negotiated amount today, the original agreement you can't rely upon.
Yeah, but the negotiated amount, if it says that we will calculate the depreciation now at the full actual cost, there could be, my lord, some kind of an agreement novating and substituting, my lord, a new term by me. The supplement, I'll immediately show that supplemental agreement.
Read further, then we'll go back.
Yes, sir.
Read further.
Yes, yes. Kindly. It's quoted, my lord.
Yes.
The modified clause of the supplemental agreement reading thus: annual fixed charges depreciation. Depreciation will mean the depreciation as notified by the Government of India from time to time and provided under the Electricity Supply Act, and shall be first computed to the assets of the generating station and thereafter apportioned to the purpose of etc. etc. Then, Lord, depreciation for the period
not computation, but this was not to override the original agreement, but only quantification done. Quantification done is by mistake, but it was very simple quantification. You don't have to do so much calculations in that.
No, how to spread the remaining period was provided for the balance.
Sorry, I couldn't get that.
Lord, now, my lord, we are now providing for a per annum depreciation. Correct. To recover the balance depreciation after adjusting whatever the depreciation they have already received.
No, this must be the first year of operation.
No.
2000 July?
2004 onwards.
No, 1 minute.
Yes, sir. First year of operation is
no, this the depreciation for the period so and so is for 10 years.
Yes.
The supplementary agreement is dated what?
18/12/2014. 2003.
2003. Yes. That's the first year of operation.
No. First year of operation is much before, my lord. 97.
96,
97. 96.
97 is the first year of operation.
Yes. 96, my lord. Single cycle operation is 96. 97 open cycle operation is 96. Combined is 97.
When did you say this amount is not
Immediately. I'll read through the correspondence again. Not immediately.
Immediately.
No. I'll point out.
Or after some time.
I'll give you the exact date. No? You pay
the fine for 1 year.
Okay. Yes. Yes.
10/2004, I have pointed out this thing to them.
Okay.
Yes. Yes. Lord, I would point out, Lord, the letters where they have agreed the depreciation will be on the allocated capital cost, even during the negotiation and after that.
Rajnath, we continue after recess, but tell us one more thing.
Yes, sir.
How did this figure of 4084 come about?
Yes.
Is there any indication on your files? Nothing. Somebody must have done the project cost calculations at that time.
Clear competition.
Somebody must have examined. You see, you may be right to one extent. The terms and conditions of contract to be changed will require a complete renegotiation and approvals right till the top. Because you are a distributing company, a government-owned distributing company. You will have to move to the legal department. All the business rules of procedure will apply. Whereas computation in terms of the contract will not require such a detailed exercise. It will be primarily a calculation exercise. But how did you come across this, come to the figure of 4080?
Well, after that, I'll explain that one. It has to be a conscious act on my part
to
change the 957.80
to rescind the contract or renegotiate the
to
contract.
substitute, my lord, for the purpose of depreciation, a higher capital cost. I'll point out from the correspondence, my lord, both before the supplemental agreement and after the supplemental agreement, they reiterate that depreciation will be on the allocated project cost. Subsequently, my lord, they are now wriggling out of two things, saying that depreciation is not admissible for the open cycle operation. And my lord, for the purpose of depreciation, we have agreed, only for the purpose of depreciation, we have agreed on higher.
Okay, we'll see afterwards. Apologize for the delay. We had some. Yes, please.
Before I go to the further portions of the Honorable Appellate Tribunal judgment, my lord, kindly come to page 360, my lord. Your lordship's pointed question, what was the working sheet for 40.84 crores, my lord? Kindly come to 360 from part of the GRC order.
Yes.
The top, my lord, the amendment to subclass so-and-so of the
61. 360 starts from here. That different.
360 is something different.
361, my lord, probably.
11.4 it starts and then here 361.
Your lordship has.
Yes. The State Commission has corrected some mistakes in the corrigendum dated so and so.
No, I'm sorry, my lord.
This is 360.
360 only, my lord. 360.
360, 11.5.
Volume 1.
At the bottom, perhaps.
Top, my lord. It's handwritten 360.
No, 360 in the compilation or the.
No, volume 1, Lord. I'm so sorry.
Volume
360 is this?
No, it's volume 1.
Yes, volume. It is amendment to sub.
Yes, Lord. That's a class.
Plus.
That's a class.
At the bottom, 11.5 mentions this. Oh, I see the early
Yes, Lord.
also.
Just before 11.5, Lord.
Yes.
On the top, Lord.
Yes.
Amendment to subclass C of class 7.1.1 of Schedule 7 of the PPA, depreciation for the period 1st July 2003 to 1st July 2013 shall be paid at so-and-so. The above amendment in the PPA indicates that the petitioner and the respondent agreed to revise the depreciation amount payable by the respondent as rupees so-and-so per annum for the period 1st July to 1st July 2013. There is no document on record specifying that how the above amount was agreed between the parties and derived by them. Once both the parties have agreed, my lord, I'll come back to this. Just to indicate, my lord, there's no working available, my lord, on the record even before the GRC. My lord, on that basis, my lord, if I may show few letters, my lord, at around that time, Lord, if your lordship would kindly come to the supplemental agreement, Lord, which is at page 161. Same compilation, Lord. The supplemental agreement, Lord, at 161 and 162 gives some recital but does not indicate, Lord.
But it is dated as amendment to the power purchase agreement.
Yes, Lord. For 163 onwards, only amendment, the exact amendment has been provided for. No details, Lord, nothing. And your lordship would also note, my lord, that there is no change in the capital cost or approved capital cost in any of these amendments. What is important, my lord, if your lordship would kindly come to 165.
Here's the figure with regard to
163.
163.
163 class 4. Class 4. And your lordship may also see the wordings, Lord, I was about to come, Lord, after the depreciation.
Look, it is worded as amendment to.
Yes. Yes, amendment to class 7.1.1. Although, Lord, it's not really an amendment, it's addition to 7.1.1. The depreciation for the period, for the future period, my lord, from 1st of July shall be computed. No provision for amendment of the capital cost, nothing of that sort.
Can we get out of it?
Lord, if lordship would kindly come to 165, 19th December. That's my lord.
What's the date of this?
18th December.
What is it? 18th of December.
18th of December. Lord, the reading of this letter would indicate, my lord, 18th December dated supplementary agreement as a draft, my lord, for signature came to GEB. And this is the letter by which, my lord, they've returned that agreement. Kindly see, my lord, if I may read this letter, my lord. In pursuance of the above and settlement in terms, settlement of the terms of modification of the PPA, concluded with the negotiating team constituted by the state government, we are pleased to authorize settlement of the outstanding issues as under various issues, like minimum alternative tax, what would happen, 20% deducted, all those, interest on working capital, rebate. And if your lordship would kindly come to the next page, my lord, item number 9, refund of depreciation, 31.37. The matter is under examination in accordance with the provisions of the PPA, up total, etc.
What do you mean refund of depreciation?
The depreciation, outstanding depreciation, I have to pay to them on that particular date, according to their claim.
They had made a claim for 31.31.
Yes, outstanding depreciation. And
this is immediately one day after that.
My lord, it's, my lord, if your lordship would see the wordings after that, my lord, it is on the, it is for,
please.
In addition,
31.37.
Yes.
Is a refund.
Yes.
This letter is dated 1912, which is one day after the signing of the agreement.
Correct, Lord. The letter further indicates, Lord, on 19th December, we are returning the supplementary agreement duly signed. That's wordings, Lord.
Yes, that's okay. You're it.
Yes.
Okay.
Yes. Although it is dated 18th December, it came to us and we have signed, and through this letter we have returned that supplementary agreement. I may just read it, Lord. In addition to the payment, etc., my lord, if your lordship would kindly come to the next page, my lord, that will be clear. The draft supplementary agreement submitted by you, along with your letter dated 8th November 2003, is approved by the competent authorities. The same is separately signed and delivered. The letter might have probably prepared on 18th December, also, my lord, but almost contemporaneous, both the documents. And if your lordship would see the table, my lord, there is no such thing of change in the depreciated capital cost allocated to GEB, which should be the consideration.
Okay, can you show us that the tabulated over here is 12 items?
Yes, Lord.
Get incorporated in the amendment?
Whatever is agreed to, my lord, it gets incorporated. Kindly see, my lord, if your lordship would kindly see from 163.
Yes.
This is related to the incentive, my lord. For the figures 6,000, it should be 6132, which means, my lord, instead of the 6,000 in the past, the incentive will be payable beyond 6132 hours on an annual basis, my lord. Then, my lord, the class wise, what was agreed to there was class wise put into this one for the amendment to the PP.
You had more than a month to look into the supplemental agreement before you signed it.
Yes.
It was given to you on 8th November 2003.
Yeah, draft.
And you signed it on 18th December.
Yes, Lord. Yes. But in regard to the depreciation, we said that pending with the authorities, etc. There's no change which has been provided for in that my letter to them saying that it will be discussed. But Lord, it will be interesting, Lord, what happened subsequently. There were discussions. In the discussions, they again agree that depreciation will be allocated cost of GEP. 90% of the allocated cost to GP. I'll point out, Lord, 3-4 letters. Kindly see, my lord, after this, 169, my lord, if your lordship would kindly come to. that refund of depreciation of 31 point so and so was not yet settled, my lord. This letter comes. Depreciation amount withheld by GEB, your lordship, my lord. This refers to the various meetings we had on the subject above with Chairman GEB and other senior officials on the above subject, and we request you to again kindly release the above amount which has been withheld by GEB for more than 1 year. Meanwhile, we would also like to confirm as follows. GEB may release 32 crores which has been held back at the earliest. We also confirm that the depreciation amount to be paid to us over the life of the PPA should be limited to 90% of the project cost allocated to GEB.
But this is prior to that. This is 22nd of September.
Next year. After 18th December, after the December,
to the 22nd.
The pleadings, have they anyway pleaded? How did the figure of 4084 come about?
I'll point out
power company.
After two letters, after this, I write a letter to them. After that, they have given a letter in which the calculation comes.
Yes, let's see.
Yes, kindly see, my lord. Firstly, my letter, my lord. Next page, 170, which refers to this one, my lord. We refer to your letter dated 22nd September 2004 on the above title subject. In accordance with the discussions and your above letter dated so and so, a detailed working has been done. The method adopted is as follows. Working up to 30th of June 2003, that is, effective date of supplementary agreement, has not been revised. The amount of rupees 30.50 crores earlier deducted have been refunded. The amount admissible up to 30th June 2003 is deducted from the total depreciation payable, that is 90% of the GEB approved depreciable project cost. The balance amount payable from 1/7/2003 onwards is divided by the number of months remaining up to July 2013, 120 months, and hence monthly depreciation payable is worked out. The difference between the total amount payable from the date of the supplementary agreement and amount actually paid is worked out to arrive at the amount actually recoverable, which comes to 26.39 crores. My lord, per annum, it should be per annum. This recoverable amount of rupees 26.39 crores has been adjusted against payable of rupees 30.50 crores, the differential amount of rupees so much being refunded to you. The amount shall be paid to you along with your bill for the month of September. GEB shall pay rupees so and so, etc. of the depreciation for this balance period. This is without prejudice to the rights and conditions of BP. Then, my lord, if your lordship would see the annexure 1 to this letter at page 172, our computation has been given starting, my lord, with the project cost of 300 megawatt power plant as 957.82 crores. The things are worked out. And if your lordship would come to the second part of the table,
yes,
from 1996-90, 97 onwards, what is the depreciation at the rate of 43 lakhs which has been paid, amount has been given, and that 0.43 and 0.43 of the first two entry is up to the open cycle period, and the third entry onwards is a combined cycle period, and everything has been calculated. And if your lordship would kindly come to the amount, in the entire amount is calculated. Yes, total amount.
Total amount is 41160 point something.
794 crores.
So if we reduce it by to 90%, it will work to?
No, it's a total depreciation amount, no? If the lordship would kindly see.
Less 90%. Let's
772 crores, no? Which you have given in the first table.
772 crores.
776 crores. 776.
76 crores.
42 crores.
Yes.
On which, my lord, the depreciation amount is payable. That payment, my lord, is given here. And
this is a yearly amount.
That is a total. No, that is a depreciable project cost, and yearly amount are all on that, my lord. Whether it is 7.90% or 4%, my lord, where there is no dispute, all those are stated, my lord, here. If your lordship would come to June, the total amount paid.
Okay, so this is the balance amount which is paid.
Yes. And last, from the bottom, if your lordship would come to the third entry, my lord, it's a 26.39 crores is a per year one.
That amount is privileged.
Crores has been, sorry.
Depreciation.
Yes, ma'am.
It is 486.26.
Yes. Already paid.
Already paid.
All these payments.
Look, this is the table we have given it in the note of submissions, also not comparative. Which is the date of that letter?
Payment of this 4,884, you never made the payment.
Yes, bro. Yeah, as per our calculation, all payments have been made. And wherever there is a delay in the payment, delayed payment surcharge has been paid.
1 minute. As per this amendment of 1812,
yes,
you have to pay 484 crores.
Yes, sir.
When did you make that payment of
yes,
40
crores? Yes.
There's 40 crores or
40
crores? 40 crores.
Yes, 40. Not this plot.
It's payable in 10 years, so it will become 40 crores
yes,
per annum.
Yes.
This is 4,084.
It's in 40 crores per month is 29 crores.
Response to this letter?
Yes. My lord, if your lordship would kindly see, my lord, there is one letter of 15th October. And my lord, the two letters of 15th October, by mistake, my lord, one letter has been filed, another letter, my lord, if I may hand over, my lord, it's a part of the Lord Court record, my lords. they raise the issue, my lord, if your lordship would come to the table, my lord, and that shall explain, my lord, it's from the going through the wordings, my lord, the table itself, their stand comes, my lord.
Yes.
If your lordship would kindly come to the table, at the bottom is, my lord, 40. If your lordship would top, lord, if your lordship would see capital cost for calculation of depreciation, they've taken it as 925 crores instead of, lord, the 778 crores. Sometimes crores.
And how do you get the figure of 778 crores?
862. Kind of, lord, if your lordship has this table, and if your lordship would take the page 10 of the note of submission. Note of submission.
170.
Here, we could done the full calculation. 950.
Or the calculation, compare it with the previous calculation to previous page, Lord, itself will show.
Page 172, our calculation.
Kindly see, Lord, 172 of our calculation.
57.82, which is where we start.
This 925 crores is, Lord, on the basis of 1768 after adjusting, Lord, the land cost, lease cost, then 358.2855, which is our thing, comes to, according to them, 925 crores for calculation. Whereas, Lord, it should be 862 crores.
And then 90% will get to 770.
Kindly see, Lord, the table which we have given. Depreciable project cost is 862.69 crores.
Then 90% will get to 770.
And if 90% of that is taken, it should be 776.42, where according to them it is 832.66.
Same figure.
Same.
This 925.18.
Yes, ma'am.
You've given it as the depreciable project cost as considered till date.
Yes.
What is that for?
No.
In your table also, 172.
172?
Page 172.
925 figure is tallying with the figure.
That's the figure which they are starting with.
Yes.
Why have you given that figure if that is not of any relevance?
No, that we have said so, Lord. As considered till the depreciation project cost.
Depreciable project cost.
As considered till date is
that is the figure that should be accepted. Once you yourself say that is the depreciable project cost.
5.18.
No.
Okay. The 1 minute now. This 920.5.18 is mentioned in page 172, your appendix is said.
Yes, ma'am.
And it is said depreciable cost, a project cost as considered till date. So probably you went by the figure of 925.19 and then you realized there was a mistake in calculation of the depreciable project cost in terms of the original agreement and therefore you modified it.
No, not the original agreement. As regards the supplemental agreement. As regards the supplemental agreement.
No, I'm saying something in your favor, Mr.
Yes.
Ramchandra,
Yes.
not against you.
Yes.
6 years they paid on this basis.
925
yes.
was the project cost till the date of this letter.
Yes.
Correct?
Yes, ma'am. Yes.
925 was the project cost as per this letter.
Yes, ma'am.
Forget about the original and the supplementary agreement for this.
Yes.
Now, by this letter, you have reworked the project cost.
Yes, ma'am.
And you have excluded from the project cost certain elements.
Yes.
Like
yes.
Depreciation paid, so and so. You have excluded. Did you? What you have done is
yes.
You have excluded from this project cost
yes.
land and lease value.
Yes. Yes, ma'am. That's what
because if we add the land and the lease value, the figure will come to 9. You have your working with regard to 925.
Yes, yes. Yes, ma'am.
Where is that page?
Yes, if your lordship would kindly come to my page 10, my lord, of the note of submissions.
Yes.
925 comes in the third table, my lord, which is the note 2, calculating from 1768.58, that comes to 925. And kindly see, my lord,
1 minute. The cost is so much. Cost of the land is so much.
Yes.
Cost of the lease is so much.
Yes. Depreciation is 1588, and our share will be coming to 925 as per the 58%, 42%.
Okay. And what have you, how did you reduce it then to 776?
No, that is the second table, my lord. If your lordship would see note 2.
Okay.
Note 1.
Note 1.
Yeah. Calculation of 862 crores as per GUVNL. For GUVNL allocated capacity, we start with 945 crores, adjusted to 957, and then reduce the land, etc. It comes to 860.
But no, the difference which is coming out is,
yes,
you have said project cost of so and so as per PPA and approved financing price is 945.
Yes.
Project cost as per the
CRISIL report.
CRISIL report
is the equivalent project cost.
How did you come to the figure of 945?
So the PPA, not the PPA says so.
It says 945.
PPA itself says 945, which becomes 957.
Just read out that portion.
Yes, 160, my lord, volume 2.
EPS 945.
Capital cost 7.
Yes, it says, you're right. EPS is 945. So they took the project cost as 1768.
Yes, for 515 megawatts.
Accepted it because still this letter.
What is the correspondence?
Letter.
Yes, ma'am.
This 8/10/2004 letter.
Yes.
Under which you enclose this detailed working.
Yes, ma'am.
So you are admitting that you accepted the depreciable project cost as 925.18 till that date. Because you mentioned that figure also and said that till this date, this is what you were treating as the depreciable project
If your lordship would kindly.
Why would you have done that?
No, my lord, if your lordship would see the covering pages, it's not accepted, my lord. It is what they are alleging, my lord.
No, this is your working. In which you say as considered till date.
As considered.
So you are now changing the depreciable project cost under this working.
I would not have, my lord, because I would not have changed, my lord, if your lordship would kindly see my covering letter, my lord. That will explain the thing. If your lordship would kindly come to 8th October, my lord, 24 letter. And I also show, my lord, the previous letters, etc. Always it was agreement that depreciable project cost will be 957.
Why would you have made this entry in your table?
Yes,
that this was the project cost considered till date.
Yes,
unless you accepted it as such till that date.
From the supplemental agreement to this date, they are contending it, my lord, via discussion. What you are saying is till date.
Your plain language is considered till date, which implies that you accepted it till that date.
Not if I have
Not that they are contending and you're disagreeing. Your language in this table means what it means. It says depreciable project cost as considered till date.
Yes, bro.
Then so you'll have to explain why you accepted it till that date.
Your Lordship, see the other document, my Lord. Could I have accepted 925.1 crore?
No.
Independent of this document.
Ramchandra, what is being pointed out is
Yes.
that in your calculations, which you had done to accept the figure of 40.85, you had taken the project cost as 925.
Yes.
When you reworked or you went deeper into it, you came to the conclusion 925 cannot be the project cost.
Yes, sir.
Because as per the project cost agreed between the original agreement, it was 957.82, which means 945 plus that thing. The project cost which they have worked out is on an entirely different table mechanism which was never there in the original PPA.
Yes, bro. Yes. Lord, let me start with Lord. The project cost in the PPA is 857. Depreciable project cost can never be 925, Lord. The project cost itself is 957. How could a depreciable project cost from the beginning could be 925, Lord? I have paid them return on equity, interest on loan, incentive, everything on 957.
You have to pay that also on to them on that basis.
Yes, everything, not everything is based on the capital cost. Everything is based on the capital cost.
That rate of return, the rate
is
only on that basis.
Yes, I'll show from both the judgment of the appellate tribunal. I think they accept that that's the correct thing.
Otherwise, it will lead to an anomaly that as far as depreciation is concerned, is going at a higher figure, whereas the actual project cost or for the purpose of rate of depreciation, etc., is at a different.
I'll give a simple calculation, Lord. My total, no, I'm not even calling it as a depreciable project cost. My total approved project cost as per the financing plan is 957.78 crores. Out of which, Lord, for the purpose of depreciation, 10% is automatically gone. That goes, Lord, to 862. Then the land, etc. gone. It comes to, Lord, much less than 800 crores, on which the depreciation is payable. Today, my Lord, if this table shows that I have accepted 925, which means that I have accepted a higher capital cost than the financing plan, they should be entitled to, my Lord, all tariff element, starting from return on equity, interest on loan, incentive, interest on working capital, operation and maintenance expenses, all are based on, I can show you Lordship, Lord, the PPA, all are based on capital cost. It could never be, my Lord. And kindly see, my Lord, my cover letter, my Lord, the annexure is explained in the cover letter. Cover letter doesn't say that I accepted 925 crores, etc. Yes.
Discussion. It is as follows.
Make it out, it's a case of mistake or arithmetical mistake in calculation.
The arithmetical mistake is, my Lord, starting from the fact, my Lord, it has to be based on depreciable capital, depreciable project cost based on approved project.
Your basis for that is simply this, that the supplementary agreement did not modify the terms and conditions. It only quantified that amount. The quantification is made wrongly.
The supplementary.
But that's not correct. The supplementary agreement uses the word amendment.
Lord, supplementary agreement, I'll modify, my Lord. Supplementary agreement only fixes, my Lord, what per annum depreciation they will be entitled to from 1st of July 2030.
And how did you come to this figure of 31 crores, which was to be negotiated?
No, 31 crores is not.
Refund depreciation of what do you mean refund depreciation?
Refund, my lord, in the sense that, no, it's not a refund of, if your lordship would see, my lord.
Page 164, you have said refund depreciation of 31.37.
Yes.
Or what is this?
Kindly see, my lord. Just take it out. Supplementary. This is a refund which amount I have withheld from them. It's not it's a cheap lot 169. It makes it clear.
Now, just tell us one thing.
Yes.
If the depreciation was fixed at 40.84,
yes, ma'am.
Then would this refund be refundable to them? Would this refundable be paid to them?
It will be payable to them because, Lord, it's a working out of an amount.
What is this figure of 31.37 crores?
31.3, but Lord, if your lordship would kindly come back to the table, Lord, at where we have given.
Page 10.
No, Lord, page 172. Page 172.
Yes.
Yes. So your lordship would see, my lord, there are depreciation admissible to them from 1996 onwards.
Yes.
We have withheld 31 crores from their invoices. That amount has to be refunded to them. That is what, my lord, they are also referring to. If your lordship would kindly see me that last entry.
So what you are saying is that as per this table, you had withheld a sum of rupees 31 crores.
Yes. In the depreciation.
In the depreciation.
Yes.
Payable.
In the bills raised by them.
Yes. In the bills raised by them.
Yes.
You had withheld depreciation of 31 crores.
Yes.
And therefore, in your table, when you say the matter is under examination according to the provisions of the PPA, you do not refer to the supplementary agreement. You are referring here to the PPA.
Absolutely.
Therefore,
Supplementary agreement, no changes to it.
no. There's a contradiction, therefore, coming in the supplementary PPA and the letter which you had signed.
Lord, I'll put this in, Lord. There's
no, but how is suppose you had agreed to the figure of 40 crores, 0.84 crores.
Yes.
Then this amount of 31.37 crores would be refunded, would be payable to them.
Would be payable to them, Lord. In any case, it would be payable to them because it relates to the past monthly dues which I have withheld on account of the depreciation. Because there were lots of negotiation, I didn't pay minimum. Lord, if your lordship could see the settlement, that letter, kindly see the letter, Lord. I'm so sorry to trouble your lordship.
No, we are only on one thing.
Yes.
The supplementary agreement, were you at item or there was a mistake by you on the figure of 40.84 crores?
Yes.
Was it a considered decision by you that you have to pay depreciation at the rate of 40.84 crores per annum or not?
Yes. My submission is, Lord, there was no conscious considered decision.
In order to accept or reject that depreciation, we have to look at antecedents.
Yes.
As well as
absolutely.
After communication.
Yes.
Now, but in this case, we have the letter dated 19/12/2003.
Yes,
by which you had sent the supplementary agreement.
Yes.
In the letter dated 19/12/2003, you referred to the question of refund of depreciation.
Yes.
You have clarified that this refund of depreciation, really speaking, means the amount which you had withheld from the bills raised by them.
Yes. Yes.
And with regard to that, 31.37 crores was raised.
Yes.
Can you take out the letters on the basis of which they claimed the depreciation?
Depreciation at 44, Lord?
No, till then.
Lord, till then, Lord, as I pointed out in the GRC decision, Lord, they say there's no correspondence for 48.3. What is till then payable, I'll show it to you, Lord.
Why don't you show us these two letters, 8th November 2003 and 3rd December 2003?
Yes, sir.
Addressed by them, which you
It's not
mentioned at the reference portion.
Please get those letters.
Yes.
Please just get those letters.
We have not.
Because, and just calculate how did this figure of 31.7 crores come?
Yes, yes, Lord. That we can give it to Lord. Your Lordships.
Because here you are saying the matter is under examination.
Yes.
You're not accepting that you have already accepted their demand.
Yes. Yes, Lord. What we are saying, Lord, there are a lot of dispute in regard to various things which are mentioned at page 165. Kindly see, Lord, where we have said under examination, what we have settled and what we have not settled are all listed.
165.
165, if your Lordship would kindly come to 165.
Yes, we have seen that.
Yes, kindly see, Lord, the remarks are also there. Resolution, whether it is resolute, some is dropped by them, some is, Lord, EPL has waived, then, Lord, the claim is admitted completely, DPS, etc.
Get your original files.
Yes.
Before the get your original files.
Yes.
As well as, and the other thing is, and how this figure of 31.37 crores has been worked out.
Yes.
Which must be based upon their letters making that claim. Your claim, in fact, as per your calculation, the total claim made by them was not 31.37. It is 30.50.
That's what's settled, my Lord, in Annexure 1.
Correct.
See, the last.
Correct.
Yes.
Just get those original files.
That was bill withheld, which we have paid. Agreed.
Just get those original files.
How did the figure come down?
31.37.
That's it. What? in December 2003 to 30.50 in October 2004.
Yes, kindly see, my lord, that was on the
But it's a
February.
very odd thing. You see, we are dealing with two commercial men.
Yes.
Not something or commercial bodies. We are not dealing with laymen who can make mistakes.
No, but it's not a mistake of 31 to 35.
Not that.
Not that.
It's
40.8 crore.
We are dealing with commercial people who should be aware of when they sign papers. It's not understandable one-off transaction, the buyer and seller agreeing to something. Sometimes mistakes can happen in that.
It's not even something you signed on the spur of the moment. You took 40 days to look into that supplementary agreement. Then you sign it and you send it.
Yes.
And then you say, I made a mistake.
Not assuming, my lord,
It's an agreement.
My lord, the agreement cannot be, my lord.
Can we sit and appeal over an agreement?
Lord, agreement cannot be, my lord. I will pay much more depreciation than the admissible, and we have immediately.
What prevailed upon you to sign that agreement?
Lord,
After
immediately
40
after
days
the
of
discussion
deliberation.
starts. Immediately after that, the discussion, as soon as I write the technical discussion starts, they acknowledge the discussion.
Where is your letter saying that I made a mistake? You said that you raised a dispute about this.
Yes.
And you informed them
It is, my lord, it is evident from their letter, my lord.
This 8/10/2004 is the letter you referred to in the morning.
Yes.
8/10/2004 doesn't say anything about being having made a mistake about this.
Kindly see, my lord, page 169. Page 169. (169), my lord. 169. It is their letter which comes in September. Refers to the discussions. Kindly see, my lord, the second.
Depreciation on 90% of the project cost.
Yes.
It doesn't say anything about why you agreed upon that figure.
No, that's why, my lord, this.
Where is your dispute raised with regard to that figure? You never raised it. You said 8/10/2004 letter, you raised it.
No, my lord,
You've shown us the 8/10/2004 letter. On the other hand, in that letter, you say that we have approved your supplementary agreement, we have signed it, and we are delivering it to you.
No, my lord, kindly, my lord. 22nd September 2004 is after the supplemental agreement. When, my lord, the implementation issues came.
Mr. Ramchandran, you signed an agreement which contains a clause.
Yes.
You must have realized at some point of time that I made a mistake or that figure is wrong.
Yes.
You should have at least addressed them and said that we made a mistake. That figure should not be read as it reads.
Yes.
This is the correct figure to be read there.
Yes.
When did you address that correspondence to them?
That is during the discussion, my lord. That's why they come and accept the second bullet. We also confirm the depreciation amount to be paid to us as per the during the life amount shall be.
That is not sufficient.
90%.
That is not sufficient to infer what you want us to infer from.
Lord, if this is implemented, the second bullet is implemented. 44.
In your wisdom, you agreed upon that figure after 40 days of thinking over it. It's an agreement that you sign.
Yes, Lord.
Can you now come before us and say we want to back out? You sit and appeal over our agreement
Lord,
and change the terms of our agreement.
My submission would be, my lord, I will not say this, Lord. Yes, I signed the agreement with 40.85 crores. The 40.85 crores, my lord, is only an amount which is mentioned is payable over a period of 10 years from July 2030. No variation in the depreciated capital cost, no variation in the approved capital cost. Nothing would not. The effect of that would be if that 90% reaches much before the 10 years, then they are not entitled to more. How can they overrate? I can understand, my lord, per year it is payable 48.85 crores. But suppose, my lord, after the 8th year it has already reached 90%. By law, my lord, they are prohibited from having much more than that amount. It is only saying that per annum I will pay.
What is this? Just come to the letter at page 169.
169, my lord.
Yes.
Okay.
Refers to the meeting we had on the above subject with senior officers.
Yes.
We request you to kindly release the above amount.
Yes.
That is with regard to the depreciation amount.
And
this amount refers to 32 crores.
Yes, Lord.
This is also depreciation amount.
Yes, the 31.87 crore which they were claiming, that has been rounded to 32 crores. This is the letter written by them.
Earliest.
Yeah.
So till September, you did not release this.
Yes, that amount. That is why that refund say that subject to discussions, etc., which is provided there. Next bullet is important, Rod. They give the confirmation. Today their case.
Okay, get hold of the details. Let's not spend more time if you have to adjourn it.
Yes,
you have to sit again in bench of 3. But please get those files.
Yes, bro. Okay.
These meetings also, there would be minutes of these meetings?
May not
These
be.
are meetings
just
which
check
are
it up.
referred to?
Just check it up.
If there is a minutes, Lord, we will produce it, Lord.
Please just check it up.
Yes.
Right.
From 97 to 2000.
We are aware. We are
accepted the figure.
They are aware of that, but they then, you see, we are just examining whether it was a mistake or it was a genuine. They came to the right figure. They have accepted the figure. The mistakes.
Anyway, we'll place on that.
We are not concluding. We have put the questions to them. Let us just have a look at them. If we find there's nothing in it, we'll dismiss it.
I'm grateful. I'm grateful.
Yeah, during the course of hearing, we felt it is necessary for the applicant to produce before us the relevant files, pursuant to which the supplementary agreement dated 18/12/2003 was signed and executed, and whether there was any discussion or calculations made to arrive at the figure of 48.84 crores payable towards depreciation.
40.84.
40.84 crores payable towards depreciation. First up, the invoices raised by the respondent towards depreciation, as well as the letters dated 8th of November 2003 and 3rd of December 2003 will be placed before us. In case any minutes of the meeting dated meeting referred to in the letter dated 22nd September 2004 were recorded, the same will also be placed before us. So the said documents will be filed along with the affidavit of the authorized officer of the applicant within a period of 4 weeks from today. Relist in the 4th week of relist on 29th of January 2024 at 2 p.m. 25 at 2 p.m.
Would it be one day prior, not 29?
This is going to be Wednesday.
Or week before or week afterwards?
Okay, it's fine. 5th of February 2020.
Yes. Lord, in case, Lord, I am not able to find it, I would request, because it's an inter-party, Lord, all the minutes are with them.
The onus will be on you.
Yes, yes. In case, Lord, they want to, if I don't produce whatever
it is, we'll have to draw inference one way or the other. If you don't produce it,
they can also provide it.
If they have it, onus will be on you.
Minutes mean, Lord, both of us are.
No, look, the onus will be on you. Your records should be better.
No, I will make the first effort, my Lord, to produce all the things, Lord. If I have to succeed, my Lord.
Okay.
Company structure, arbitration.
My lords, we are being led by Mr. Ranjit Kumar. He is currently in his legs in another court. So, my lords, we mentioned it in the morning, and my lord said that
the request of the council for the appellant, appellant, the appeal is not taken up for hearing today. You remain on board.
my lords may also note that they have recently filed a counter affidavit. So, my lords may allow me to file a rejoinder in the
Meanwhile,
meanwhile.
rejoinder affidavit may be filed within 2 weeks.
My lords.
Please, Lord.
115
Petitioner, my lords, I am suffering from lung infection, therefore I am requesting for an accommodation till Wednesday. Wednesday, I have an appointment with my doctor.
Been granted bail.
What is this? Last time also we took an adjournment.
Lordship, I am suffering from lung infection. I am not able to speak longer than 1 or 2 sentences.
At the request of the council for the appellant who stated to be indisposed, the appeal is not taken up for hearing today. To remain on board.
Much obliged.
Lordship, item 113, which was just adjourned, is it again at 2 p.m. on 5th of Feb?
No, yes, at 2 p.m.
At 2 p.m. I'm very obliged.
Yes.
Yes, Lordship. Your Lordships are aware.
You are appearing for the respondents.
I appear for the respondent.
This matter will require consideration. Let it be heard and disposed of.
They can file a rejoinder, my lord. Otherwise, my lord, the distinction is, my lord, in pay scales, my lord, and stipend. These are, my lord, students who are supposed to get stipend. They may not qualify. They have to sit for the same examination. They have to.
Which examination?
The NEET.
No, NEET is something similar. That you are right.
Yes.
But then NEET is the rest of the students go in the other one.
And services.
The duties are different. You'll have to consider that. There's a detailed judgment of Justice Balasubramaniam.
I read that. But that was on pay scales, my lord.
That's fine, but this is a stipend. How much is the stipend otherwise?
No,
Now it is increased 30%.
We have been given, my lord, we have stopped being given, my lord, 2016 on.
What was the stipend being earlier given?
Subject to correction, my lord, was how much we were getting?
10,000.
Now 30,000 they are getting.
10,000 where today they are getting, my lord, and they also.
Now 1 minute. What is effect as per result of the judgment? How much is the stipend now?
My lord, they are getting, I think, my lord, now 3 times more than what we are getting.
No.
3 times.
1 minute, please. What is the stipend now? Earlier you getting 10,000.
How much are you?
Now you're getting how much?
Now we are supposed to get as per the latest GEO 2023 GEO.
No, please, let's not forget.
13,000. There is GEO, Lordship.
No. You go to the hospitals in the evening. I know. I've been to some of the Safdarjung or for that matter, Lamron, Roy Hospital. We'll hear you out. We are not saying that. Only thing is, let it be heard. Right, doctor.
Today we are not getting anything at all.
No, that will be paid. The earlier stipend will be paid.
No. 30% has been increased, Lordship.
That's
There is a GEO.
1 minute, please. What they are saying, stipend is not being paid. Please ensure the stipend is paid.
They are getting.
Right, doctor.
With the areas.
With the, all the areas should be.
Having regard to the judgments of this court, in 2017, 1 SSC 148, and what's the citation, Justice Balasubramanian subject?
Lord, it is State of Gujarat versus Lord Dr.
And State of Gujarat and others versus PA Bhatt and others.
Civil appeal number 8
Civil appeal number
8553
8553
and 8557
8557 of 2014. You have the opinion that the order dismissing the specially petition in limine should be recalled, reviewed, and the matter should be heard on merits. Stop. Accordingly, we allow the review application and recall the order dated 24/7/2023. Full stop. Resultantly, notice will be treated as issued.
Already entered a hearing.
Notice will be treated as issued in the special petition.
Not page 30.
And the same will be listed before the bench, before appropriate bench, in the week commencing 10th of February 2025. Reply. So counter affidavit to the
Its content is already.
specially petition may be filed within 4 weeks, rejoinder if any, within 4 weeks after service of the counter affidavit. In the mean, we also deem it appropriate to direct that the respondents
all
the paid stipend,
his last column,
including areas, if any, in terms of GO number, GOM number 177, dated 6/10/2023. That is 6/10/2023. Full stop. The payments will be made regularly, and areas, if any, will be paid within 2 months.
But can we have a fixed date now? Because there's
Giving
because there's students may not be also.
1 minute, we are giving a fixed date. That week commencing is a fixed date. Review application is disposed of.
Okay.